Recording has begun.
Chair LaHood, do you want to introduce the meeting? Okay. This is the City and County of San Francisco regular meeting of the Compliance and Amendments Committee of the Sunshine Ordinance Task Force. Remote access and or in-person participation. The Sunshine Ordinance Task Force and its committees convene hybrid meetings that allow in-person attendance, in-person public comment, remote access for petitioners and respondents, and remote public comment via teleconference. The WebEx remote link login information is /tinyurl.com/3F9KDEAD. Password is Sunshine. The telephone call-in number is 415-655-0001. The meeting ID is 2601189692##. You press *3 to enter the speakerphone. Members of the public may participate by phone or may submit their comments by email to sotf@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at /sfbos.org/sunshine.
Can you hear me? Okay. Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to the disorderly conduct of meeting participants. Persons who engage in threatening and or menacing behavior may be asked to leave. Please call the first item.
Item number 1, call to order, roll call, and agenda changes. Let's begin with roll call. Member Pilpel, absent. Member Anderson.
Present.
Member Anderson, present. Member Wolf.
Present.
Member Wolf, present. Chair LaHood.
Present.
Chair LaHood, present. We have a quorum. I am not aware of any agenda changes. Nobody has contacted me. Chair LaHood, do you have other information?
I do not.
Okay. Do we want to open this up to public comment?
1 minute. I thought I saw a message that one of the parties is not going to be present for one of the items.
When did this come through?
This came through. It was for Rosa L. Hold on. Let's see.
Member Wolf,
Item
may I
number
have a
6.
timestamp, please?
It was June 21st at 9:20 a.m. from our office email. It says Lila CAC members, please see below regarding next week's CAC hearing, Cheryl. And then the messages from Rosa L. Heads up, I will be unable to attend this meeting on this day.
I don't think I was actually, you said June 21st. I don't have that email.
I'm
Your
checking.
name is in there.
I'm checking as well.
Oh, you know what? I do see it. It's threaded.
Yeah.
So that would have been Friday.
Yeah, Cheryl, so you didn't see this?
No, I saw it, but the agenda was already up.
Okay, so,
There's
but
something I can change it.
we know that this person is not coming then.
I believe Member Wolf is correct.
Okay. So,
Clarification, I actually see the timestamp as Thursday, June 20 at 4:50 p.m.
that is correct. It looks like June 21st is when Cheryl forwarded it. So, so the person did get in touch with us before the deadline. Although at a very difficult moment to do anything about it. Well, Unless, Ms. Leger, unless you've heard anything else from Rosa L., I think we should assume that she's not planning to attend. We were notified, I mean, it was too late to do anything else about the agenda. We couldn't have put anyone else in this position, but I'm thinking we should probably continue this matter.
Please note that we have Victor Lim in the online community.
Members, what do you think we should do about this?
Considering that she did notify us,
Mm-hmm.
I would say we continue it to our next meeting.
It wasn't a timely notification. That's not enough time to give the other party notice that they don't have to appear.
Well, I mean, it was before the agenda. Ms. Leger, from your perspective, I understand how that happened 10 minutes before the end of your workday on Thursday, and how you might not have seen that, and the agenda was sent out as it was. But I believe she did notify us more than 72 hours before the meeting.
Mm-hmm.
So even though it would have been nicer had it been earlier, and it probably Mr. Lim would have appreciated knowing sooner. I agree with Member Anderson that I think we continue this. Member Wolf, do you have any thoughts on this?
Sorry, fumbling with the mute button. No, I'm in agreement, and whatever our protocol, outlines.
So, Mr. Lim, thank you for appearing at this hearing. I apologize that we did not notify you sooner that this cancellation happened, but rather than having you wait around for someone who I don't think is showing up, I think we should strike this matter from the agenda or continue the matter and try to schedule it for our next CAC hearing.
Mr. Lim has a request to speak. Mr. Lim, would you like to hear him speak?
Victor Lim here.
Sure.
Oh, may I ask, just procedurally,
Yes.
when is the next date? I just wanted to note that for me personally, I would not be in office from July the 10th to the 26th. So it's best that I am present to speak on this matter at the next hearing.
Well, the good news is our next meeting isn't until August.
Oh, good. Okay, wonderful.
Okay. Yes.
Yes. And just to let you know, we are providing things on a rolling basis to this case right now. It's well addressed. So it's all positive news that we can share formally at the next hearing.
Great. I appreciate that. I was, since we're going to need you to appear at that next hearing,
Yep.
I'm not going to ask for an update now, but I'm
Right.
glad to hear that informally.
Yeah. And then my question is, if something like this is notified by the other party in the procedures, do we get a courtesy notice that the complainant or the case person has informed that they can't appear? Because I'm just learning about this now, and this happened before in the past. We just want to be more efficient here.
Yeah, I agree with you. And I apologize. I did not see that, but Ms. Leger, in the future, even if we are sending out the agenda, I would say in the future, if we've heard from someone, even if it's at the very last minute, I think it would be, I think we should give a heads up to the other party. Since it was on the agenda, I'm glad that Mr. Lim showed up, but it might have been helpful for him to know that it was likely that we weren't going to hear this.
I agree.
Yeah. Okay. Mr. Lim, I think we are in agreement, and we will try to make sure that happens next time.
Okay. Wish you all the very best, and we'll see you in August. Okay.
Thank you.
Thank you. Bye-bye now.
Okay. So we were just talking about the agenda, and so we won't be hearing item number 6, which is file number 24001. We're going to continue that to the call of the chair, ideally for the August meeting. Any other changes that anyone knows about? Hearing none. Ms. Leger, let's take public comment on agenda changes.
This is Pat. If there's anyone in the room who would like to make public comment on item 1, roll call and agenda changes, please approach the podium. Members of the online community, please raise your hand using *3 or use the app. I'll give you a moment. Chair LaHood, we have no hands raised.
Okay, Ms. Leger, please call the vote. All right. Yeah. Yes.
Chair LaHood,
Aye.
Chair LaHood, aye. Member Wolf,
Aye.
Member Wolf, aye. Member Anderson,
Aye.
Member Anderson, aye. Member Pilpel, absent. Administrator Peterson, just for your own knowledge, there is no one in the room other than the Chair LaHood and Member Anderson, and Member Wolf is online.
Thank you.
Ms. Leger, please call the next item.
Item number 2, approval of the February 27, 2024 Compliance and Amendments Committee meeting minutes. On April 16, 2024, the Compliance and Amendments Committee moved to continue the minutes to the call of the chair.
Ms. Leger, I have a question. I know that Member Pilpel often has he submitted any edits that he had on these minutes?
No.
I mean, this is from 2 meetings ago, so these are from February.
If he submitted, I can't speak off the top of my head if he did submit it. I mean, I don't have any outstanding
Okay.
documents to edit.
Okay.
Okay, so he does, I do have waiting for him a copy of the packet that includes these minutes. So if he wants to make edits, we can certainly introduce that at the next compliance meeting.
No, I just wanted to know, because these have been on more than one agenda, if they have been, it looks to me as though they have been updated, but I just wanted to confirm that with you.
Yeah.
Okay. Members, do we have any edits to these minutes from the, February 27th Compliance and Amendments Committee meeting?
Nothing for me.
Okay. Member Anderson, any updates?
Nothing for me.
Okay. No edits from me. Do we have a motion to approve these minutes?
So moved.
Okay.
Second.
Okay. Member Wolf will be second. Ms. Leger, please open this up to public comment.
Hang on a second. Do we want to open this up to public comment?
Yes, please.
Okay.
I see no one approaching the podium, and we have no hands raised in the online community. There appears to be no public comment on item 2.
Okay. Ms. Leger, please call the vote.
Member Anderson?
Aye.
Member Anderson, aye. Member Wolf?
Aye.
Member Wolf, aye. Chair LaHood?
Aye.
Chair LaHood, aye. Member Pilpel, absent.
So the motion passes. Please call the next item.
Item number 3, approval of the April 16, 2024 Compliance and Amendments Committee meeting minutes. This is the first time they've been reviewed. So give me your edits.
Okay, members, I was not at this meeting, so I'm depending on the two of you to offer any edits based on your recollection. Are there any changes that you would recommend to these minutes?
Nope, they seem okay to me.
They seem fine to me.
Okay, do we have a motion to approve?
I'll move it.
I second.
Okay, we have a motion to approve in a second. Let's open this up to public comment.
Seeing no one approach the podium, we have no public comment in the room and no hands raised in the online community.
Okay, Ms. Leger, let's call the vote.
I just want to make sure, Member Anderson moved and Member Wolf second, is that correct?
That's
Flip.
correct.
I'm sorry?
I was second this time.
I think so. They switched. Yes.
They switched.
Yes.
Which,
Yes.
okay. Apologies. I'm ready for public comment.
There is no one in the room and no hands raised in the online community.
Okay, Ms. Leger, please call the vote.
Member Wolf?
Aye.
Member Wolf, aye. Member Anderson?
Aye.
Member Anderson, aye. Chair LaHood?
Aye.
Chair LaHood, aye. Member Pilpel? Absent.
Please call the next item.
Item number 4, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda.
I see no one in the room and there are no hands raised in the online community.
Okay, it seems that we don't have anyone here. I know with the full task force, we typically wait until 5 o'clock, but that's not a requirement for this meeting. Is that correct?
That's correct, yes.
Okay.
That's only for the task force.
Okay. Then please call the next item.
Okay. Item number 5, file number 23053, complaint filed by Sergei Zveranov against the police department for allegedly violating the Administrative Code Section 6721 B as in boy by failing to respond to a public records request in a timely and or complete manner. Excuse me. On
Okay.
August 15, 2023, the complaint committee found that the task force has jurisdiction, the records are public, and referred the matter to the full task force with the recommendation for a violation of Administrative Code Section 6721. On June 5, 2024, the Sunshine Ordinance Task Force moved to refer file number 23053 to the June Compliance and Amendments Committee agenda to investigate consolidation and closure.
Ms. Peterson, can you confirm, do we have both parties here?
Petitioner Severanov has not called in. Lieutenant Beauchamp has been made a panelist.
Okay. Have we heard anything from Mr. Zveranov?
Give me a moment, please. On Thursday, June 20, at 3:06 p.m., Mr. Severanov indicated that he would be present.
Okay. Here's what
One
I
moment.
would, yes.
Wait, 1 moment, please. Different meeting. Hold on. Let me confirm. That is confirmed. This was a notice from the administrator about the June 25 meeting requesting confirmation of his attendance by June 18. He responded on the 20th.
Okay, that he would be in attendance.
That is correct.
And Lieutenant Beauchamp is here and has been made a panelist.
That's right.
Here's what I would like to ask if no one has any objection. I know we moved very quickly through the first part of the agenda. What if we were to take just a 10-minute break now to see if Mr. Zvernoff shows up? I know sometimes people don't expect us to be hearing matters until after 5 o'clock, and we are a few minutes ahead of 5 o'clock. Does anyone have any objection to taking a 10-minute break and reconvening at 5:05 to see if Mr. Zvernoff shows up?
I'd give it 5:10.
Okay. Does anyone object to waiting until 5:10? Member Anderson, Member Wolf?
No.
No objection.
Okay. Lieutenant Beauchamp, could you come back at 5:10?
That's perfectly fine.
You're
Sorry, sir, we didn't hear you.
So that's perfectly fine.
Okay.
okay. Great. We're going to adjourn the meeting briefly. We will return at 5:10. In the meantime, Ms. Leger, if you could turn off the microphones, and we'll be back in 15 minutes.
Yes, no, it's recess, not adjournment.
Excuse me, recess. We are recessing for 15 minutes. Thank you, Mr. Young. I appreciate that. Recessing. We will be back at 5:10.
Administrator Peterson, we would like to reconvene the hearing today.
All right.
What time do you have on your clock?
5:11 p.m.
And Ms. Leger, please call roll again so we can confirm which members are in attendance.
Member Pilpel, absent. Member Anderson.
Present.
Member Anderson present. Member Wolf.
Present.
Member Wolf present. Chair LaHood.
Present.
Chair LaHood present. We have a quorum.
Ms. Peterson, could you confirm? So we are returning back to Ms. Leger, if you could state the item we're on, and if Ms. Peterson could confirm whether the petitioner and respondent are with us at the meeting.
Okay. Item number 5, file number 23053, complaint filed by Sergei Zveranov against the police department for allegedly violating Administrative Code Section 6721B as in boy by failing to respond to a public records request in a timely and or complete manner.
Mr. Zveranov is not in the room. Lieutenant Chris Beauchamp is a panelist.
Okay. That is unfortunate. I also want to make sure that the recording is back on. Is that correct? Or it was never turned off?
It was never turned off.
Okay, great. Members, what do you propose? Should we, has anyone made an attempt to contact Mr. Zveranov? Do we have a cell phone number for him?
One moment, please. Still checking.
Just for point of reference, I've never been able to speak with Mr. Zveranov on the phone. I've only communicated with him through email.
I do not believe I see one. I will continue to check. I don't want to hold up this discussion, however.
Okay. Members, what do you propose that we do here? Unfortunately, I thought we had some momentum on this since this was just heard on June 5th, and I think there was interest in getting this matter resolved and closed. But do you think we should postpone to our next meeting?
This is Member Wolf.
Mm-hmm.
I would maybe suggest, since this has already gone through a complete process and this is confirmation about documentation, whether it's been fully disclosed or provided. The only question I have is I don't have necessarily a definitive list of items that I could corroborate.
Right. I think that's what the challenge is. And also because Mr. Zveranov has several cases with us, I wouldn't want to inadvertently sign off on something having been taken care of because of our misunderstanding that it has to do with one case versus another.
All right. Then I would be open to continuing this to the next meeting, but Mr. Zveranov needs to be a communication made to him that he must attend, or we're going to close the file.
I think that's, yes, Ms. Peterson?
I'm sorry to interrupt. I am going on mute. I'm going to make a quick phone call.
Okay. While Ms. Peterson is doing that, Member Wolf, I am in agreement with you. I think our communication to Mr. Zveranov should be, since he had confirmed that he was attending the meeting and we expected him here and have not heard anything otherwise, that we will reschedule this for our August meeting with a plan to that his attendance is required if he has any ongoing compliance issues, but otherwise we plan to close this matter at the next meeting.
But we also have to advise him that he can reopen this issue.
Of course. And he can reopen, you know, if,
It's within 6 months of
with-
closure.
is it 6 months or 60 days?
60 days if the case is closed. You can reopen it for another hearing, but I think in this instance, it could be 6 months. I'll check my rules.
Let's verify that. Let's verify that in the rules. Lieutenant Beauchamp, are you on the line?
Yes, ma'am. What do you need?
Yes, I'm sorry that we don't have the petitioner here today, but if we are not going to be hearing this, I would rather let you go quickly than have you hang on with us if we're not going to be able to hear this case. Do you understand that I just heard a sound. I don't know what that was about. But Lieutenant Beauchamp, would you be available to return in August pending confirmation that the petitioner will be able to attend?
Yes, of course.
Okay, I think that was an assent.
That
Yes.
was affirmative.
We're just having a little trouble with your microphone. Okay. Let's wait to hear back from Ms. Peterson, but unless she has some new information.
I do. Mr.
Oh.
Severinov is calling in right now.
Okay. Okay. Lieutenant Beauchamp, do we still have you?
Still here, ma'am.
Okay. Sounds like we are hearing this case.
I hung up from the phone call, so I'm awaiting his call in.
Okay. Thank you. Thank you, everyone, for your patience. We appreciate it.
I just want to make sure that I can hear Lieutenant Beauchamp because he seems to have a very tinny sound to his speech. Can you guys hear him well enough?
It crackles a lot.
And it's faint.
Is he on, are you on is he on speaker? Lieutenant Beauchamp, are you on speaker? Is that the reason why?
I'm on headphones, but I'll try to switch over to my computer's microphone to see if that picks up any better.
Actually, it was a little better the last time you spoke. I don't know if it's because you were speaking a lot more loudly or moved the microphone, but that was a little better.
Okay, I'll try to speak up.
Thank you.
Thank you.
I also want to reiterate that, and I double checked this last week, that the notices had gone out to all parties timely of this hearing. So just wanted to let you know that.
Still waiting for him to call in.
Okay, thank you.
One moment, please. Checking. We have a caller. We have Mr. Severinov. One moment, please. Mr. Severinov, you've been made a panelist.
Mr. Zvernov, is your microphone active?
I think so. Yes.
Okay, great. Thank you for joining us. I'm glad that you're here. We are having this meeting following, we had a full task force hearing that you were not able you were not in attendance, and the full task force asked the Compliance and Amendments Committee to take a look at this. And Lieutenant Beauchamp was at that last meeting, had said that his department had provided you records on several dates, and that on March 4th, he had sent a letter to Ms. Leger and to you that included links to body cam footage. The reason for our meeting today is to confirm that you have received the materials that you're looking for pertaining specifically to this complaint. And if so, we would like to close this matter. I know you may have other ongoing complaints, but we're looking specifically at the items for this matter. Could you give us, well, I'll give you a few minutes to tell us what you have received, or if there's anything that you think is still outstanding specifically pertaining to this case.
Okay, the case in question is...
This is file number 23053.
23053. So this is the a complaint. This is their complaint that I made due to a lack of disclosure by the racist SFPD based on their racial discrimination against me and my immigrant family. SFPD is a racist organization headed by a racist chief of police, and Lieutenant Beauchamp, a racist executing the racist policies. As many immigrant families will live in constant fear of SFPD. In this particular case, SFPD entered without warrant my residence when I was not there, when my wife was not there, and molested my minor daughter. I have subsequently made a request for information based on the Sunshine Ordinance and California Public Records Act. The request I made had 29 points that I have requested. That actually included a very detailed specification of what I was looking for, including their CAD numbers, police reports, their squad cars, as you can see in the items 29, 27, 26, the number of units there. In response, I didn't get anything like that, anything on that. I only received partial footage, redacted, of some officers entering my residence, and then it cut when they entered it. So the only thing that they provided is partial body worn camera footage. They haven't made any search of their databases. They haven't provided police reports on that incident. They haven't provided CAD. They haven't provided any records of their the positioning and the activities of SFPD units number 3F13E, 3F14E, 3F118, 3F110, 3F13D, and these are the units that I have identified as participating in the persecution and molesting of my daughter. Now, of course, they want to cover up their molestation of my daughter, and they have not provided. And shame on you, SOTF, that you are here covering up the persecution and molesting of a minor immigrant child. San Francisco is a sanctuary city. Well, you are racists in this sanctuary city. You're covering up You are allowing this racist Beauchamp
Mr. Zvernoff, can you
to
give
get
us,
out.
are there any other specific documents
You are
that you are
racist.
missing?
You are racist. And
Mhm.
that's what I want to say. And you cover up for racists. And then I told you specifically, what do your racists want? What other specifics do your racists want? I have identified the CAD number. I have identified the unit numbers. And I got nothing on that.
Okay, Mr.
All I
Zvernoff,
got is just the partial footage. No
Okay.
police reports. No CADs. No CAD records. No information. No records of those police units. And in response, the SFPD, as usual, said, we interpret this as you want information on the body worn camera footage. That's not what I look for. And you know, you are racist. You think we immigrants are stupid. That's how you treat us. You American racists. Shame on you. Shame on you. This is something that I will keep a record of. And whenever one of you tries to go for electorate office, I will bring this up.
thank you, Mr. Zvernoff. Thank you for your update. Lieutenant Beauchamp, can you tell us about what has been provided and respond to Mr. Zvernoff's, actually, he said that you sent him partial footage. Why was the footage redacted?
The footage in question, which was sent to Mr. Smirnoff on multiple occasions, was redacted to maintain the privacy of any witnesses or victims who may have called in regarding the incident in question. In addition, any CLETS information was redacted out, anything that would have been seen on computer screens or heard over the air that would have been protected and prevented from being disseminated per the CLETS ordinances in the Penal Code. I believe those were the primary two factors of information being redacted. There may have also been potentially juveniles who answered the door in the incident in question. I believe we redacted out their image under the understanding that they may be underage.
So, but this was at Mr. Zvernoff's residence, so ostensibly these were his family members whose likenesses were redacted?
Not necessarily. The incident in question, there apparently were multiple juveniles at the residence, and when the police officers responded, I believe the initial individual who answered the door said that they were not a resident and that they were going to go seek a resident out.
Okay. Can you describe to us what other information you have provided in response to this specific complaint?
One moment, please. Let me pull that up. So regarding the requests for any information regarding CAD numbers, we provided Mr. Smirnoff with information on the custodian of record for those documents, which is the Department of Emergency Management. We provided it with him with that information on February 16th, 2022. Let me see, I'm just running through the various responses we've sent to Mr. Smirnoff. We informed him that if he wanted any criminal history records, that he would have to make a request through our ID Bureau. We provided him with a link for any incident reports, which would be handled by our Crime Information Services Division, to make requests for any incident reports that he would be seeking. We provided him that information on February 24th, 2022.
Incident was in February 2023. You lying piece of shit.
Lieutenant Beauchamp, I'm hearing you. I was hearing Mr. Zvernoff in the background, but it was not his turn to speak. Is there anything else that you have to add?
Mr. Smirnoff, I'm going to mute you for the moment.
Okay. Lieutenant Beauchamp, so what I heard you say is the footage was redacted to maintain the privacy of witnesses and juveniles who were not members of the family, that the person who answered the door was not a resident there. You say that you provided him with record, I guess, for the CAD numbers, you told him where he could find those documents with the Department of Emergency Management, and where he could also locate criminal history records, which are not maintained by your office. Is that correct? Or you said with the links to the Crime Services Division where he could request those?
Yes, so the Crime Information Services Division, which is our records division, that's where he could request any incident reports that he wanted. And we provided him with information about how to obtain criminal history on himself or anyone else through the ID Bureau. We provided him with information on how to follow up on that.
Okay. Is there anything else that I haven't just restated that you did provide?
I'm still going through the various responses we've given Mr. Smirnov. It can be kind of difficult because multiple requests that he's made. The body-worn camera footage, I believe that's all that we have sent over in regards to this specific request.
And with regards to the body-worn camera footage, if he had secured permission by others in the video to not have the images redacted, would you be able to unredact them, or is that something that is there any further visibility? Could you make any additional parts of those videos visible if he were to secure permission from people who were captured in those videos?
If he had signed releases from any of the witnesses or 911 callers, or from the juvenile in question who answered the door, we could unredact their faces. When it comes to the CLETS information, that is solely within the purview of law enforcement. That cannot not be redacted.
Okay. Did you let him know that if he had secured those signed releases that you might be able to unredact additional portions of the video?
No, we didn't explicitly tell him that if he obtained signed waivers, we could do that.
Okay. Members, do you have questions for either Mr. Zvernoff or Lieutenant Beauchamp?
I do not.
Member Anderson.
I do not. Well, maybe one question for Mr. Smirnov. If he could tell us anything that he's received that he feels as part of his request on this, are any portions of his request completed? Are there certain items that we don't need to look at, or that because you've already received whatever information you needed, Mr. Smirnov?
I'll unmute you.
Well,
You are
have
unmuted.
in front of you my request. Okay? Now, that request contains 29 items. And again, amongst those items are a number of items that requests records of police SFPD units 3F14E, 3F118, 3F110, 3F13D. Okay? No such records were provided at all. Nothing were provided beyond the partial body-worn camera. Now, Lieutenant Beauchamp, in his perverted dreams, says that the people who answered the door were not somebody who is a member of my household. This is false. He has, as his imagination, his warped American racist imagination. That's what's working here. Okay? That's what he is. That's what he is doing, because the people who answered were not speaking with the same accent with me. He is a racist, and you're covering up for his racism. People who
We're
answered
just
the door
asking
were
for
members
your
of my
for the
household.
documents. We're just asking about the documents. That's all. Anything else is not of any of our
Now,
concern.
they have not done any search of the databases. Okay? They have not provided me incident report. The SFPD itself, in the exhibits that I have provided, has considered previously that incident report is public record. It's not a criminal record. Don't take us immigrants for stupid. Lieutenant Beauchamp is the most stupid person here.
Well, this is just not helping you, Mr. Severnov.
Yeah.
You know what?
We're just trying
You are
we're
racist
just trying
American
to get
fuck.
to the
That's
record.
who you are.
Okay.
Okay?
It's just not helping.
Yeah,
Our job
you
is
haven't
just to
provided
deal with
any
the record.
records to me. Nothing. And I demand those records.
It's just not helping you, us getting to
You know what?
answers
Don't
of the
take me for an idiot. You are going to cover up
I
for the
am not.
police.
I
You
am
are in the
not.
pocket of SFPD and the city attorney's office. That's where you are. You are a bunch of dummies. That's who you are. And
Okay, Mr. Smirnov, we're going to put you on mute for a moment while I
Yeah.
ask Lieutenant Beauchamp some questions, because I'd like to get specific answers rather than so we can move this forward. Lieutenant Beauchamp, if we go to the list of documents that were requested, and I'd just like to systematically go through this and check off and be clear about which items you have been able to provide, which items you referred Mr. Zvernoff to other agencies to seek those documents, and ones that you won't provide, and the specific reasons why you won't be providing them. If we look at item number 1, which is for a specific CAD number, hang on, let me go back to the original here.
Ending in 118.
Yes, CAD number ending in 118. So your response to this was to send him to DEM, is that correct, or was there a different response?
Yes, CAD numbers are within the custodian of records for Department of Emergency Management.
Okay. Okay. So you did not provide that, but you told him where you assisted him by telling him which agency could provide this to him. Is that correct?
Yes.
Okay. So number 2, and I'm looking at this numbering system and I'm seeing multiple numbers 2 and 3, but we have seeking information about the police presence on the block of Grove between Cole and Schrader on these specific dates. Did you provide cam footage or body worn footage in response to the request about information on these dates?
Yes.
Okay. Okay. The next one, also labeled number 2, was a similar request. Did you provide access to body worn camera footage regarding, it says, police actions against and interactions with occupants of 2151 Grove Street on February 11th and 12th?
As far as I am aware of, yes.
Okay. Regarding the first item, number 3, regarding use of force by SFPD members, offers, affiliates, informants, snitches, agents, managers, supervisors against occupants of 2151 Grove Street, again on these dates. Was the same or different camera, body-worn camera footage supplied in response to this request?
I don't believe that request is for body-worn camera footage. It's for use of force data, and we have no responsive records for that.
Okay.
Same for the second item, number 3 as well.
Okay.
And the third item, number 3 as well.
Okay. So all of the item number 3s, we have the same response here. You have no use of force data. And the absence of use of force data means that there was, that the police department, what would that mean if there is no use of force data?
That there was no reportable uses of force.
Okay. And then we have a fourth item, number 3, that says threats by SFPD members such and such about these same dates. What is your response to this fourth number 3?
I have no responsive records regarding that request.
Okay. Regarding number 4, which is presence on block of Grove Street between Cole and Schrader on February 11th, February 12th, both 2023, and actions on these date on this block by an Officer Aguilar.
Provided body-worn camera footage.
So you provided body-worn camera footage. Okay. Hang on. I'm just notating all of this. Okay. Regarding item number 5, sort of similar, but this is regarding Officer Kaganot.
Provided body-worn camera footage.
Okay. The next item, which is presence on block. I'm trying to see if this is a repetition of the previous number 4.
I believe it is. I
Okay.
don't see a difference.
Okay. I believe that's correct. And then we have number 5, which is asking about the presence of this same officer. Did you have any additional information about that other than the body-worn camera footage?
Other than body-worn camera footage, that is the same response for 5, 6, 7, and 8.
Okay, so same for 6, 7, and 8. So this was, you consider what was provided with the body-worn camera footage, what is available for 6, 7, and 8?
Yes.
Okay. And this includes, okay, then we have item number 9. So interactions between SFPD and Vera Sveranova.
As far as I'm aware, we provided whatever incident reports we had with SFPD and the person's named Vera Severnova.
You provided, you said incident reports?
Yes.
Okay. Okay. And how about for the second item, number 9?
Done that as well.
Okay, so incident reports. Item number 10, interactions with all of these types of people and Olga Tikhanova.
I believe for 10 and 11, we provided whatever incident reports we had. I don't recall if there was any specifically for either of those individuals.
So you provided incident reports that you had that may or may not have included these individuals?
Yes, I distinctly remember there being reports for Mr. Severnov and I believe Ms. Severnova, for Ms. Tikhanova and Ivan Severnov. I don't recall if there were incident reports, but if there were any, we did provide them.
Okay. And then item number 12, regarding SFPD unit numbered 3F13, hang on, I'm E, 3F14E, 3F118, 3F110, 3F13D.
So that doesn't identify any responsive records when taken in conjunction with number 13. Those unit identifiers, that information can be obtained through the Department of Emergency Management, and we provided that link to Mr. Severnov.
So you're saying that looking for information on these unit numbers, that is information that would be provided by Department of Emergency Management and you don't otherwise have responsive records?
Yes, those unit identifiers don't generate any responsive records in and of themselves.
Okay.
They just specify what a particular unit for 3, just to get a little inside baseball here, the first 3 identifies that it's a patrol unit. The letter connotates what police district. F would be for park. 1-3 signifies how many people are in the 3-car sector for park district. 2 digits means it's a 2-man car. And then the letter E for Edward signifies that it was a midnight unit. Other than that, there is nothing inherently demonstrative about that information, about that signifier. It can be rotated night to night, different officers. It cannot be used, it can be used. So taken in conjunction with 13, that would be a responsive record produced by the Department of Emergency Management, what that specific identifier was doing on those dates and times in question.
Okay. 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 And then for 14, is this something that could be responded to separately, or is this similarly something that needs to be requested from DEM?
That would be located within DEM.
Okay. But these unit numbers could be used as reference. The unit numbers and dates can be used to get records from DEM.
Yes.
Okay. And does this also apply to 15? Tell me which additional numbers on this list does that apply to?
15, 16, 17, 18, 19, 20. So you couldn't state the 20 and 21 could also be located in the body-worn camera footage that we provided.
Okay.
Because he does specify interactions and response versus just the mere presence.
Okay. Okay, so in 20 and 21, this might also be, it might be used to get records, and also some of this information could be in the body-worn camera footage that was provided?
Yes, the actual response and interaction of people within those units.
Okay. Number 22, which is regarding phone records of calls on these particular dates.
San Francisco Police Department has no response records.
Okay. And that is because
We don't track phone calls by officers.
and that is because, can you explain why?
It's just typically not part of our standard operating procedure. I could always reach out to our IT department and see if they have records that date back that would show incoming or outgoing calls. But as far as I'm aware, we don't track like the actual conversations that are occurring.
Right. It would just be a record of a call from this phone number to this phone number and the length of the call.
Yes, and that would be for any work-related phones. We wouldn't have access to any of Officer O'Rourke's personal phone calls.
Okay. And then, so number 23, would that be the same response then?
Again, it depends on interpretation of what he means by Park Police Station between 10 p.m. and 2 a.m. If he's looking for calls for service involving Park Police Station, that is through DEM. If he's looking to see actual phone calls coming in and out of Park Police Station, I am aware that we do not track, I believe it's either incoming or outgoing phone calls from police stations, and we definitely do not keep any body records of phone calls being made to police stations.
Okay, but what did you say could be secured from DEM?
If 23 is requesting any calls for service involving Park Police Station, that can be obtained through DEM for those dates and times.
Okay. And then 24.
I believe we provided body-worn camera footage for 24, 25, 26, 27, 28, 29.
Now, with this, you are saying that you provided body-worn camera footage, and this, even though this refers to the units, It's because it was interactions, and that's why this is what might have been captured on body-worn camera footage versus the other requests for information, which, if they were in documents, would have been tracked by DEM. Is that correct?
Yes. So the interpretation of the difference between the word interaction versus, for example, number 15, the presence of. Presence of can be determined by DEM can provide a record showing when a particular unit identifier was dispatched to a particular location, whether or not they showed up, and then when they cleared that location. If Mr. Svernoff wants interactions, which I believe was then clarified in further bullet points in his request, that is where the body-worn camera footage is salient to the request.
Okay. Members, we have gone through this list and we've gotten a specific response about each item. In most cases, it was either that they provided body-worn camera footage, or in other cases, where Mr. Svernoff there were a couple where they said there's no use of force data, so we have no responsive records. And then there were several items where we were told that information is maintained by Department of Emergency Management, which could use these unit numbers to track down additional information. The only ones that I'm seeing any information that was not provided that could be gotten is number 22 and 23 regarding contacting the IT department about information regarding incoming and outgoing phone calls on work-related phones. What are your thoughts on these, members? Or anything else that you noticed as we went through this that you were not satisfied with the police department's response?
Madam Chair.
Yes, please.
So a couple of things. One is I didn't see a redaction key. If there is, can you point me to the page that it's on for the body-worn cameras or any other items?
Let me look. Lieutenant Beauchamp, if this is something that you can point us to, that would be helpful.
I see a grid starting on page 35. Are those time codes?
Lieutenant Beauchamp, are you able to respond to that?
Lieutenant, I'm unmuting you. Oops.
Can you hear me?
Yes.
Okay, yes. Yes, the redaction reasons are over on the right-hand side. So we notate either possible juvenile redacted, MDT redaction, which would be for our CLETS information, and witness redaction, etc.
Okay, usually we would see a citation of law that allows for the redaction.
We've updated our units, and we're now providing that information. If Mr. Svernoff wants those specific government codes and administrative codes and penal codes, I'm more than happy to provide them.
It's not him, it's us. The Sunshine Ordinance requires it.
And we have made those changes since.
Yeah, but what about for this case?
This letter was sent out March 1st, 2024. We have made those changes. I can contact our body-worn camera unit and make sure that they are correctly sending out that information.
Yeah, but
we've also notated them up on the top above that where it says, please be advised, redactions have been made pursuant to. We do cite the specific codes, but we don't annotate them in the redaction box as well. I can have them clarify that and make it more easily to understand.
okay, because that's how it's described in the law on how redactions are to be, they're supposed to be accompanied by the citation.
So Bruce, are you asking that we have the police department add another column that would explain next to each of these explanations for the redaction, which part of the code they're citing?
Yes.
Okay.
Otherwise, it's not complete.
Okay. And what are your thoughts regarding the putting in the request to the IT department regarding phone records?
I don't see a problem with that. I mean, generally, it's just going to be logs. It's just going to probably be logs that are, of whether these calls had been made and between which, I don't know if it could identify who, but it'd be identifying probably extensions. I'm not sure, but that's probably what it is. I'm okay with that. That can be included too.
Okay. Was there anything else that jumped out at you that you thought seemed like an incomplete response or an inadequate response?
No, I get the split between the police department and DEM. The question then the question is whether if Mr. Severinoff is interested in going after that information with DEM, whether he's able to finish completing his request. It just sounds like any of the items that the PD does not have that DEM does, they have provided the unit numbers to identify exactly the reference for the items that are being requested in this list. So I'm pretty satisfied with that.
Okay. Member Anderson, do you have any questions or thoughts about ways that the police department needs to respond further than it has for any of these items?
At this point, no, I believe the issues that I had questions on have been pretty much covered in the response by Lieutenant Beauchamp. I'll end there.
Okay. So based on the conversation we've just had, I see three things that could be done in addition to what has already been provided. Noting also Member Wolf's comment about DEM's responsiveness, and they are not a party to this particular records request. I don't want to assume what Mr. Zverinoff has or has not requested from them at this point, but he has been pointed in that direction by the police department to seek some of the information on his list. The three things I think could happen still with the police department are providing with the list of redactions from the body-worn camera footage, if we could have each one keyed to the code or law that allows for those redactions. I'd like a request to the IT department for phone logs as to whether calls had been made to or from the extensions that are associated with the person or persons whose phone activity Mr. Zverinoff was requesting. And then the third thing, I guess, is more for Mr. Zverinoff, but I'd like to know from Lieutenant Beauchamp if you're recommending to Mr. Zverinoff that if he is able and or interested in submitting waivers from individuals whose image or voice may have been redacted from the body-worn camera footage, that if he submits that to you, you could unredact some of the footage. Is that correct?
Yes, if he locates any of the individuals who we redacted and is able to provide a signed waiver and a copy of their ID, we are happy to unredact their footage.
Okay. Ms. Peterson, if you could unmute Mr. Zverinoff, that would be helpful.
Mr. Severinoff, you've been unmuted.
So, Mr. Smirnoff, at this point, I would like to proceed with requesting, with following up with these two requests that we've identified where the police department could provide you with more information, and that is getting the redactions from the body-worn camera footage keyed to specific law that allows that. And if they can't key it to a specific law, those portions would have to then be unredacted. And then is it clear to you that if you are able to get waivers from individuals whose image or voice may have been redacted in the body-worn camera footage, that if you submit those with copies of their ID to the police department, that they may further remove some of the redactions in the footage that you have already received? Is that clear?
I'm not going to just follow this completely arbitrary and unlawful request from the police department. Right? One other thing I want to say is that my request was for all records regarding the interaction described in my request. The police department says we have video records about this interaction, and they think that this is enough. My request was to search for all records, which they haven't done. They have not provided to me the incident report, and that's not an exempt piece of information. SFPD has already accepted back years ago, and I have provided that in my packet, that incident reports are public information. That incident report has not been provided to me. Third thing, if some piece of information is available in one department and is also stored in another department, the fact that they possess already makes them custodian of that record. The SFPD possesses the records, maybe the same records as the DME, Department of Emergency Management. Once they possess it, they have a duty to disclose it. And they unlawfully say that because there is a record in the other department is DME, go and get it from the DME. That's basically a mockery of the law. That's basically a mockery of the fact that San Francisco is a sanctuary city. That's basically a racism by you covering up for the racist policies of the police department. And also, tell me that you believe that the police department does not keep the logs of the phone calls. This is going to be ridiculous. This is a fact. The police department has used their call logs in many investigations and criminal cases where they provide the logs of their phone communications during their criminal investigations. Here, they pretend that they don't have logs. When you call to the police department, to any station, they will tell you we record this conversation. They're telling me now, and that's when that's what I was told when I called the Park Police Station, that they record this conversation. Now they're telling me that they have no records of those phone calls. This is a racist banter. All I can say, you just completely incorrigible racists. That's who you are, and that's what determines your actions everywhere and anywhere.
Okay, thank you, Mr. Zvernoff. Our objective here is to try to get you access to as many of the records that you have requested, which is why we're going systematically through this and reviewing the responses. For those who are following along, in addition to the verbal responses we got from Lieutenant Beauchamp, on page 51, there's also a detailed text response about each of these items. This was originally prepared by Lieutenant Toomey. At this point, I understand what Mr. Zvernoff is saying about the phone records, and it is perhaps puzzling that those weren't responded to in the first place, since I think getting phone records seems like maybe one of the easier things to do. In response to his question about which departments maintain or keep records. Members, I think this has come up before. While the police department may access the records held by DEM, if they're not maintained by the police department, it's still appropriate for the police department to direct him to DEM. Is that correct? Or do you agree? Do you have any other thoughts on this about whether the police department should be supplying those records, or if directing Mr. Smirnoff to DEM is the appropriate response? Yeah, Member Anderson.
Yeah, I hate to punt, Bruce, but you've had more experience with this than I. I haven't had this come up most before in the interactions I've had. But is each department, for those matters for which they are deemed the custodian of records, are those the only items that they're required by law to produce, or do they produce across departments? Have you seen that? I'm asking the question.
Oh, yeah, absolutely. I mean, we have a section 6721C specifically describes that if the custodian does not have the record, that they shall assist a requester in identifying the existence of the record, so that the requester can continue on their search for the information that they're seeking. So if the police department says, if they get to a point, or any department, any custodian gets to a point of that they've come to the end of the line of records that they have, and they might know that the additional records on the request might be available at some other department. I mean, it's all one city. It's not, different cities. So it doesn't matter where the records exist. So that's the purpose of that section, in order to do that. Now, I agree about the phone logs with regards to the police department, but the question then becomes, from who to who, and I don't know what kind of phone logs they keep, except phone logs that would come in through like the front desk, kind of thing that they would record. Either, I don't know how they record those things, whether it's on computer or whether on paper or what have you. And then there's other, types of communication, whether it's cell phone or whatnot. I'm kind of getting at the point where, we don't have subpoena power. We can compel the production, but it only goes so far. And so we do what we can with, in trying to achieve the best possible outcome for the requester, for the petitioner, in concert with the custodians. But at some point, when it starts getting too complicated, and it seems like it requires more legal action in order for the requester to get that, that's where I kind of get to a point where we've done the best we can, and the rest has to be done through other means.
I would agree. I think that makes sense. At this point, I'd like to make a motion that we request Lieutenant Beauchamp to return to our next meeting with the following. My motion is a request that the San Francisco Police Department and Lieutenant Beauchamp return. Actually, no, I would like this submitted within 5 days, and then we'll review this at our next meeting. The body-worn camera redactions if we could have each one keyed to the code or law, and if those are truly represented by those sections of the code that were listed at the top, this is probably something that a knowledgeable person could do rather quickly. But in doing so, it would verify that each of those redactions matches one of those pieces of code. And perhaps if any of them don't, then those items either should immediately be unredacted, or we would need the appropriate section of code explaining why they were redacted. And then we'd like a request to the IT department to supply the records of phone calls for the phones managed by or responsible to the parties identified in items number 22 and 23 for the dates and times requested. Lieutenant Beauchamp, would you be able to respond to provide responsive records on both of those within 5 days?
I can definitely provide responsive records in regards to the codes. I can make a request to our IT department regarding the logs. I don't know if they'll be able to turn around within 5 days, but I will do my best to get on them. Okay.
If you could send the items you are able to regarding the redactions in code, as soon as those are available, if you could send those to Ms. Leger, please do that. And if you could confirm with her when the request has been submitted to the IT department, that would be great, so that we know that both of those things have been done. And then let her know immediately when the IT department responds with those records.
Madam Chair,
Yes.
which IT department are you referring to?
That would be Lieutenant Beauchamp. Which department would maintain the phone records for the police department?
I know our IT bureau controls the cell phones. I'm pretty sure they control our station phones, but it may end up being a request out to city IT on that one. I have to double check.
Member Wolf, does that answer your question, or does that require a modification?
It does. Thank you.
Okay. So I would make a motion that we request that Lieutenant Beauchamp take care of those two items, and then that's my motion, and then I will just restate to Mr. Zverinoff, although he didn't seem, just to restate his option of submitting waivers from individuals whose image or voice may have been redacted in the body-worn camera footage, that is, if he chooses to do so, that Lieutenant Beauchamp has agreed to receive those waivers with copies of IDs that may result in additional footage being unredacted. And that is in Mr. Zverinoff's hands, whether he chooses to do something with that or not. That's not really part of the motion. Ms. Leger.
That's what I want to confirm.
Yeah.
What your motion is.
What is part of the motion are the request to Lieutenant Beauchamp to, within 5 days,
Provide
send
the body-worn camera with redactions keyed or assigned with code or the law.
Yes.
And to verify that each of those redactions, and perhaps if any one item should be unredacted, the code explaining why redacted, and the code explaining why it's redacted, and request the police department, IT department to supply the records of those phones managed by the parties in items 22 and 23 for the dates and times requested. Also confirm when the request has been sent to the IT department and a response has been received.
Yeah, and maybe if we could just, when you write that up, break that into item 1, which has to do with the redactions, and, or, number 1 and number 2, which has to do with the phone logs.
Item number 2 is what?
The phone logs.
Phone logs, okay.
Just because I know there were a lot of clauses in that.
Madam Chair?
Yes.
Just to touch on one additional thing Mr. Zverinoff was pointing out about all records pertaining to his request.
Yes.
There are no additional records. We do not have an incident report for that CAD number.
You do not have an incident report for that CAD number?
Yes.
Is there an incident report not associated with that CAD number, but associated with the time and location of the events that he's describing?
No, there's not.
Okay. Can you explain why there wouldn't be, given that there's all this other material?
Because officers are required to activate their body-worn cameras when they respond to calls for services, but not all calls for services equate into incident reports.
Okay. So there was a call for service, the body-worn cameras were turned on, but this call for service did not rise to the level of an incident report being created. That's what you're saying?
That is correct.
Okay. Members, are you satisfied with that response?
Yes.
Member Anderson says yes. Maybe she'll speak into the.
Sorry. Yes, I am.
Okay. Member Wolf?
I have no other knowledge to go under any other kind of information. I can ask the same questions the petitioner is asking and that you're asking. It seems odd to me that an incident report for any call would not end up with some sort of written report somewhere. But that's the answer that we're getting. So that's all we can accept.
Okay. Thank you. So I've made a motion. Would anyone like to second my motion?
I'll second.
Okay. Do we have anyone wishing to make public comment? There's no one in the room, but Ms. Peterson, is there anyone on the line who's not party to this case who would like to make public comment on the motion?
There's no one online.
Okay. Members, any additional thoughts or amendments? Okay. Ms. Leger, please call the vote.
Chair LaHood?
Aye.
Chair LaHood, aye. Member Wolf?
Aye.
Member Wolf, aye. Member Anderson?
Aye.
Member Anderson, aye. Member Pilpel, absent. 3 in favor, 1 absence.
So the motion passes. Mr. Zvernoff and Lieutenant Beauchamp, we are eager to see your quick response on this. I would also ask that in addition to sending those responses to Ms. Leger, if you could please email them to Mr. Zvernoff as well so that he has access to them as soon as they're available. And then I am hoping that we can review this again at our next meeting in August, at which point I hope that Mr. Zvernoff will have received the additional information that we have requested. And I think that is as much as we can do with this particular case at this time.
My apologies.
Okay, I think we're done with this matter. Mr. Zvernoff and Lieutenant Beauchamp, thank you for being here today. We appreciate you taking the time. And again, as I said, we are striving to help members of the public access the information that they're looking for in terms of public records and access to public meetings to the extent that we are have the authority to do so. So thank you, everyone. Ms. Leger, if you could please call the next item.
Item number 7, committee members will review the Sunshine Ordinance and discuss possible amendments to recommend to the full task force. Recommendations proposed by members of the public at previous committee meetings will be taken into consideration. Discussion and proposed action to forward the recommendation to the full task force.
Okay, so I'm sorry that I wasn't with you, all members, for the last meeting. I have been listening to your discussion, and I have not completed, but I have been typing additional edits into a document that I then hope to share at the next meeting. My question to you is, and I don't know if you saw in the attachments, I put an index at the top because I asked Ms. Leger to include the Sunshine Ordinance, even though for members of the public who might be joining us, even though it seems that we have no members of the public here, but following the ordinance were additional documents that this committee has generated over time, including, if I can get there past the ordinance, annotations to various sections. And Ms. Leger, thank you for printing this in such a way that shows the line edits and the comments. And then One page ended up upside down.
Sorry.
And then beyond that, we had additional comments from earlier meetings, some edits that had been recommended by San Franciscans for Sunshine, and other notes on this. My question to all of you, at this point, what would be the most productive thing for us to do? Should we go back to, the top of the ordinance and talk about what specific, which of these specific suggestions we think we should move forward? Should this, would you like me to go away and try to consolidate this more into a comprehensive list of suggestions that then we would say thumbs up or thumbs down on? I don't know. How can we get from the work that we've done so far to a next step to move this forward? What do you recommend?
Okay. I believe one of the things we need to determine is what our next steps will be. What do we want to see? Do we want to then present this maybe to the Board of Supervisors or we'll present
full task force first?
Task force, absolutely. And get whatever suggestions that they have. So I like your idea of consolidating the information together so we have it all in one spot. And then we can suss out which are the most important to move forward. And we can also determine which ones we can take any kind of action on as members of the task force, because maybe we wouldn't want to present anything that we know that the task force can't really have, doesn't have the power to push forward.
Mm-hmm.
And maybe the things that will make differences in how we operate and the more efficient way we can operate and supply public records. Maybe those are the issues that we'll start pushing forward on.
Yeah.
So.
And I want to hear what Member Wolf has to say, but another thing that crossed my mind as I was reviewing some of the earlier notes we made on this, maybe we also, I don't know if it would be worthwhile requesting some assistance from our deputy city attorneys, because there's one note in here that says from Member Wolf, someone should review Penal Code 832.7, to see if we need to add sections for meetings and for records regarding police activity and closed sessions. Mm-hmm. I mean, the question is, do we want to, would that be helpful to ask for their feedback on that? Would that move things along faster, or would that slow us down? Member Wolf, what do you think of that suggestion, and Member Anderson's general thoughts on how to move forward?
Well, I agree with both. I think the other thing to kind of expedite things is to items that are purely type clarifications or typographical. Mm-hmm. I think are of more immediate, kind of more trivial and easier to kind of move forward. Mm-hmm. And those should be notated. I'm not sure whether I think maybe also if we can conclude with an agreement with certain sections, that we start moving those sections forward to the task force.
Here's a question then, in terms of, just because we meet every other month, the next task force, full task force hearing is in, wait, I forget, because we moved from the 4th of July. Ms. Leger, when is our next meeting?
Compliance?
No, task force.
August 7th.
Oh, so not until August. Okay. Well, here's a thought. Actually, that gives us a little more time, or gives me a little more time. I have two thoughts. What if I were to create two versions, one with what I perceive to be like the simple edits that are like updating language and things that are kind of, Bruce, as you said, the sort of the trivial things, and put all of those in one document. And then in a separate document, consolidate the comments that and questions we've had, and maybe also pulling in the recommendations that have come in from the edits from San Franciscans for Sunshine, but to split things up into trivial and substantive in two different documents. Do we think we'd be ready to, if, Chair Yankee was willing to at least share both of those with the full task force, or do you think we should look at those ourselves in August and then try to share with the full task force in September?
Well, I think we need to come to some agreement in this committee
Mm-hmm.
and then approve it by a vote. So that way it's clear that we're, have completed our work on those sections,
Mm-hmm.
at least for review, and then move it that way. I would feel uncomfortable that we would just move things forward without having some sort of final discussion about those items without a vote.
I think that makes sense. Do you have any concern about, although since, since the next, well, do you have any concern on timing if we were to do that in August and then present to the full task force in September? I mean, obviously nothing's going to, it's, if I know there was talk of ballot initiatives, that's not going to happen this year anyway, right?
Right.
No.
So in that case, then would that make sense that we plan in our August meeting, and perhaps since it's only 6:30 now, depending on how long you would like to work on this evening, perhaps if we would go back to some of our earlier notes, reviewing like the earlier sections, and maybe do a gut check and see, does this still make sense? Is there anything we want to definitely say, yes, let's do this, or no, take that out? Would that be helpful at this point?
I'm okay with doing that. My
Mm-hmm.
my only concern is Member Popo.
Yeah.
Yeah.
Then you know what? If we want to wait and come back in August and hope that he will be in attendance with us, and in the meantime, this would give me a little time to work on the split documents, where we could have the one where we think, these are sort of the trivial versus the substantive, and maybe even in that meeting, we could go over, maybe we'd be moving some back and forth until we get the version of, these are the things that we think are simple and just about simple and non-substantive, and if anything, maybe we can get that subset moved forward while we figure out our plan for the second set.
The more substantial
Yeah.
ones. Yeah.
Sounds good to me.
That makes sense to me.
Okay.
Since we're not moving anything for a November ballot,
Right.
then we should take our time and make sure we
Let's get it
what we
right.
want. Yeah.
Yeah.
Get it right.
Yeah. Any other thoughts or things that you'd like to see happen? Or are there any, actually tell me this now, are there any sections where there's something that either of you feel personally very strongly about, where it is a substantive change, where you might like to take the first pass at writing what those changes would be?
I do have one section.
What's your favorite section?
Well, there are a number of them, but it would be in the 67, starting in the 6720, the public records section.
Okay.
But we're not quite there yet.
Okay.
As far as the public meetings is concerned, the only thing I probably would want to take a double take a double look at is maybe passive meeting bodies, but not crucial.
And remind me, how far did you guys get in the last meeting?
We got to. Let's see. I don't know that we did. Hold on. Let's see my notes here. See. I think we got to 6712.
Okay. Would it be just, knowing that there will be another opportunity to review more with Member Pilpel, should we go ahead and maybe do a few more sections? Like if we do, I'm hearing
Oh,
Morse
sorry
code.
about that. Sorry. Go ahead.
Would it be helpful for us to review maybe 6713, maybe 13 through 17 this evening, just to at least would you feel comfortable reviewing those, knowing that we'll have a chance to go back and get Member Pilpel's comments on those as well?
Yeah, I think that's okay. I'm not sure if we finished with 6712. I think they're. I don't know. I don't recall. I'd have to go back and listen to the audio.
Yeah, and I hadn't gotten all the way to the end yet. I was in your discussion of 6712.
Okay. All right. Yeah, I'm okay with going through 6713 through 17.
Let's do that. Okay, let's give everyone a few. And Ms. Peterson, at this, I'm assuming we still have no one else on the line. That it's just us.
That is correct.
Okay, here's what I'm going to say. Everyone, take 5 minutes. Read 6713, and then we'll discuss.
Okay.
Are we ready to discuss?
I believe
Yep,
so.
I'm ready.
Okay. I have two specific thoughts, but I would like to let both of you go first. What jumps out at you as needing modification?
I believe, excuse me, I believe some language, this is Member Anderson. I believe some of the language as far as how disabilities are described in terms of saying physical, but there's more than that as far as disability. So I don't believe we should box it into just physical disability. So we may want to do some work around striking physical from the wording. Let's see, what else do I see? As far as translations are concerned, I believe there was an article that was passed around
By the San Francisco Public Press. Thanks, Bruce.
regarding AI translators. And I think that we ought to address, it should be addressed somewhere in the ordinance that it's not only human translators that can be used, but if the technology advances to the point that using a computer enhanced translator would be in the best interest of making sure everyone understands what it is that's going on in the public meeting, that be made available also. So those are the two things I want to bring up right away. How about you, Bruce?
So I have a number. I agree with that, both those items. I have a couple other items, actually a number more, and some of them I kind of are repetitive. I think of San Franciscans for Sunshine also. So in the first sentence, where it says no policy body shall conduct any meeting, conference, or other function in any facility, I would add or in a manner that excludes persons on the basis, so on and so forth. And, as Member Anderson mentioned, removing the word physical. In B, remove each board and commission enumerated in the charter and replace it with all policy bodies.
Yep.
And then continuing, shall provide sign language interpreters, comma, assisted listening devices, comma, note takers. So strike or, note takers, comma, and then or other needed accommodations for persons with disabilities or people with disabilities. At each, and strike the word regular, at each meeting or at any meeting. I don't know. I don't know which is the better verbiage for that. Provided that a request for such services is communicated to the secretary or clerk of the policy body. And then strike board or commission at least 48 hours before the meeting.
I have a quick question. If it's secretary or clerk of the policy body, is our secretary or clerk the appropriate terms, or should it be secretary, clerk, or administrator of the policy body?
It could be secretary, clerk, or other.
Okay.
And then put in whatever word should be in there, staff, or I don't know. You could add, listed secretary, clerk, administrator. I mean, I'm not sure, other than us, whether there is any other policy bodies that has an administrator, that manages things. I mean, every policy body does it kind of differently. But yeah, whatever's appropriate there.
Okay.
And then strike everything, and then of the of the and add policy body period, strike the rest of it, and then add.
Wait, when you say strike you don't want to strike the at least 48 hours before the meeting, do you?
Yes, because
Really?
I'm going to add a replacement language for that.
Okay.
When requests for such services are made by a member or members of the public at least 72 hours prior to the meeting, comma, the policy body shall comply with the request, period. If the request is made less than 72 hours before the meeting, comma, the policy body should attempt to comply with the request, comma, if possible.
Okay. Got it.
All right. Then moving forward, C again would remove each board and commission enumerated in the charter and replace it with all policy bodies. Nothing additional there. D, same thing. No additional other additions there. And E would remove the Board of Supervisors and replace it with all policy bodies.
Okay, hang on 1 second. 1 second. Sorry, what did you say for E?
E would strike the Board of Supervisors and insert all policy bodies.
Okay.
Shall seek to provide translators at each of their regular meetings and all of their committees. Now, there may be some constitutional construction language that they use the word it as an object instead of a pronoun. So I'll leave that up to the legal minds for that one.
Okay.
All right. And then continuing committees for each language requested, where the translation is necessary to enable and remove San Francisco residents and replace it with members of the public with limited English proficiency to participate in the proceedings, provided that a request for such translation services is communicated to the strike clerk of the Board of Supervisors and replace with policy body.
Okay.
At least 48 hours before the meeting period.
So 48 hours, not 72.
Correct, for this section.
Okay. And then where it says the clerk of the Board of Supervisors shall first solicit, what do you want to place that with? The policy
body?
Okay.
Yeah. And then for the next couple of lines, wherever it says the clerk of the Board of Supervisors, replace with policy body.
Okay.
And then strike the very last sentence. In any calendar year in which the costs of the city provide translation services, blah, blah, blah.
Yep.
Okay. All right. Then two new paragraphs.
Okay, hang on 1 second. I do want to I'm going to make a suggestion because on this, a couple sentences up, it says if these options do not provide the necessary translation services, the policy body may employ professional translators, or should we say, or technology solutions that provide real-time translation.
That's fine.
Okay.
Yeah.
Yeah, any augmentation
Okay.
is fine. But the thing about augmentation is, one of the problems with online translations is, dealing with various dialects or colloquial,
Right.
passages, translation, it's more interpretations than translations.
Right. And I mean, we've had interesting discussions about this where you think, well, if it's nothing or something that gets you 80% there, is that better? But then there's a concern that does an 80% solution then create a sense that, well, we're off the hook for providing 100% solution?
Well, this is an issue that the school district had a problem with some years back when there was, they had received some money to provide translation services. And they found that it was far more conducive to have live speakers because, say, for either Spanish or Chinese, with so many different dialects, most of those interpreters could shift gears or kind of re-explain things if they weren't clear, where you couldn't query and some sort of technology on the fly to do that.
Right. And you said you had some sentences to add to the end of section E?
Yes. It's actually a new paragraph, F and G.
Okay.
And G.
Okay.
So F would be, this is new, each policy body shall, comma, within 6 months of passage of this amended ordinance, comma, broadcast all meetings held in City Hall on the San Francisco Government TV channel, and in parentheses, or its successor, close parentheses, or on the city's website via real-time audio streaming and or real-time audio video streaming, period. All other policy bodies are encouraged to broadcast their meetings similarly as feasible.
Can you read that last sentence one last time where you said all policy bodies?
All policy bodies are encouraged to broadcast their meetings similarly as feasible. Now, I think that may sound a little redundant. I think maybe what was meant was all other meeting bodies.
I'm going to read this back to you.
Sure.
Each policy body shall, comma, within 6 months of passage of this amended ordinance, comma, broadcast all meetings held in City Hall on the SF.gov TV channel or its successor, or on the city's website via real-time audio streaming and or real-time audio-visual streaming. All other meeting bodies are encouraged to broadcast their meetings similarly as feasible.
Correct.
Okay.
Now, the only thing that if I can anticipate a question that may come up, is there may be some meeting bodies or actually even policy bodies that may not meet in City Hall. They may meet elsewhere. Like, I don't know if any of the enterprise agencies like the MTA or the Port Authority or the PUC and the like, whether they meet in City Hall or not. So that would be the only additional thought I would have.
So it might be other city facilities.
Yeah.
Okay. You know what I'm going to do? I'm going to leave it as you have it, and I'm adding a comment that said, do any policies meet not at City Hall? Do we need to include other facilities?
Right. That's good. Okay. And then G, it's a very short one. It's one sentence. All policy bodies and passive meeting bodies shall comply with the guidelines and recommendations of the Mayor's Office of Disabilities Access Public Event Checklist. Accessible.
If you read that one more time slowly, I'm not the fastest typer.
I'm sorry.
Okay. That's okay.
All policy bodies and passive meeting bodies shall comply with the guidelines and recommendations of the Mayor's Office of Disability, and it's a possessive disabilities accessible public event checklist.
Got it. Okay.
The only concern I have with citing that particular office is that it's a mayor's office, and the mayor, it serves at the pleasure of the mayor. And in any 1 year, the mayor could dissolve it.
Right. Or
So,
a future mayor. Yeah. Yeah.
Right. So the question it would be then maybe to change that to, some sort of ADA coordinator or, some sort of oversight, who has oversight over ADA compliance in the city, that kind of thing. But, or maybe just the official, maybe there's an official accessible public event checklist that the city has or something like that. I just get a little, it feels like that it may be a little pigeonholing.
I'm going to put a note on this too.
Okay. And for that section, that's it.
This is Member Anderson. I have a quick question to posit. Within this section, would we or should we address for those members of the public who, because of whatever their disability is, can't physically come to City Hall, that they have some access to making comment through technology? Is this the spot to put it?
The hard part about that is I think I agree with you. I think we should do something like that. The question is that if you remember at the close of the pandemic, the governor was the one who made that determination through executive order, because the Brown Act does not afford for remote public comment. So unless the Brown Act has been updated to allow for it beyond the sunset, it's right now it's more or less unlawful. So even though we do it for the purposes of anonymous parties, and we're actually maintaining remote access almost for everyone, and the city in general is allowing it for people with disabilities, at least for the sitting either appointed or elected members of a body. I don't know. I mean, I know there's a movement afoot by senior and disability community groups to try and return remote public comment, but I'm not sure where the law stands on this at this point.
And this actually raised a question I had about this section was and now that I'm thinking of it, maybe it doesn't belong in the Sunshine Ordinance, but at this point, where does the city's policy live about remote access in the event of another pandemic or another, where does all of that live? And, for example, with, for members of boards and commissions, I know there are the guidelines about who may participate remotely. Where is that codified? And maybe those details should all live together and not necessarily in the ordinance, unless you think that needs to be repeated in the ordinance, which could make it a bit unwieldy.
I believe that came from up high. It came from Sacramento.
From Sacramento. Okay.
Yeah, I think that's because the governor there was this long period where nobody knew how they were going to be able to run their meetings, if they were allowed to remotely or not. So there was all kinds of executive orders that were done on a rolling basis, actually.
I remember, yeah.
And a lot of that followed Governor Newsom's lead.
So I'm hearing you say that we probably should not introduce any of that here, with the understanding that in the event that it's needed in the future, that's going to come from other quarters.
Yes, but here's I always like to be prepared. So I would posit that we actually prepare an amendment and we hold it aside, so that if at some point the Brown Act does change, that allows for additional remote public access, we have it ready. At least a framework for it.
Should we add that to the end of our list?
Yes.
Okay. Any other thoughts? I think we've made some nice edits to 6713. Any other final thoughts? I've done in track changes everything that the two of you have said or that I've read in, and then there were a couple of questions that I tagged on, asking about, do any bodies meet not at City Hall, and is there an official accessible public event checklist monitored by any other city agency, which we could then reference in addition to or instead of the mayor's.
Correct.
Okay. Should we take a few minutes to look at 6714 quietly and then discuss?
Okay.
Okay.
Are we ready to discuss?
Yep.
Okay. Who wants to go first?
I've got a bunch.
Okay,
Sure.
I figured so. In fact, I anticipated some of yours, but then I got confused between B and C. So why don't you tell me what you're thinking?
Okay. So in the title,
Mm-hmm.
strike the word video and audio and just leave it as recording, filming, and still photography.
Okay.
And then in A, after the words policy body,
Mm-hmm.
insert or passive meeting body.
Okay.
And then shall have the right to record, and then strike the proceedings with an audio or video and or digital recorder or a maybe that was my ad. Okay, I'm wiping the whole thing out. And or digital recorder or a still or motion picture camera, comma, or.
But don't you want it? So I think what you wanted to say is any person attending an open and public meeting of a policy body or passive meeting body shall have the right to record or to broadcast the proceedings.
Well, I would add as well as to broadcast the proceedings.
I think you just need an or. Oh, record as well as. I see what you're saying. To record or to broadcast.
Because they could be recording and broadcasting at the same time.
Okay.
Otherwise, somebody's going to say you can only record or you can only broadcast.
Okay.
There's sticklers out there. Okay, and then to broadcast the proceedings in the absence of reasonable finding of the policy body, and then insert or passive meeting body,
Mm-hmm.
and then the rest of the sentence is fine.
Okay.
In B,
To all policy bodies.
Yes.
I knew it.
Okay. But in B, at the end of that sentence, at the end of where it says special meeting,
Mm-hmm.
comma, including closed sessions.
Okay.
And then in the next sentence, after the word any, strike audio or video and insert other. So it's any other recording of a meeting, and strike of any other policy body.
Mm-hmm.
And it goes all the way to the end, period. Government Code Section 6250 is now 7920.
7920. Okay.
Yeah, that's the California Public Records Act. That's the new section number. Okay, and then add this sentence. Tell me when you're ready.
I am ready. At the end of the section or after an intermediate sentence?
No, after where it says California Public Records Act, Government Code Section, okay, and then it's period, and then adding a new sentence. I'm sorry.
What about and shall not be erased or destroyed?
Oh, strike that.
Okay.
And insert new sentence. These recordings shall be kept indefinitely by the city, comma, and shall not be erased or destroyed unless the recordings are being transferred into a different format for public access, comma, archival or retrieval requirements, period.
Can I add another sentence after that?
Go ahead.
Each such recording shall be posted on the policy body's official website.
Yep.
And then leaving the inspection of any such recordings, and maybe
I've got more to add to
okay.
that sentence. So inspection and then insert and playback of any such recording shall be provided without charge.
I'm going to say shall be provided. So in addition to it being on the website.
Okay, right.
Without charge, and then on an appropriate playback device, or
correct, on an appropriate playback device or software made available by the city, semicolon, and this is now a new insertion, copies of any such recordings shall be provided upon request, and payment for the actual cost of the medium on which the copy is recorded, period.
We're missing something there. Copies of any such recordings shall be provided upon request, and payment for the actual cost of the medium. We don't have any action on the payment. Who's paying?
It would be a request, whoever that is requesting
So
it.
we're saying copies of any such recordings shall be provided or upon request in exchange for payment, or because you can't just say and payment.
Yeah, I would use the same language as it would be for making copies in the public records section,
Okay, let me see if I can find that.
so that we're not reinventing the wheel.
I am not finding it, but let me just make a note that I will locate this.
Yeah, I'm seeing, so requested copies, which is what? Requested records shall be available at the cost of the material with no expedited fees.
Okay, hang on, could you read that one more time?
Requested records shall be available at cost of the material with no expedited fees.
Okay, I think we still need to specify who's paying.
Who's paying?
Yeah, covered upon request.
Requesters shall be responsible for.
Yeah.
The requester of the record shall be responsible for the cost, the actual cost of the materials used to comply with the request. And now I've got more words than I had before.
Yeah, let me think about this.
Yeah.
So
How about this?
6721L says, including disc, tape, printout, or monitor at a charge no greater than the cost of the media on which it's duplicated. There's got to be some standard boilerplate language for that.
Yeah, I'm thinking the same thing.
All right, tell me when you're ready.
Okay, how about this? I sort of synthesized what both of you were saying. Okay. Copies of any such recording shall be provided upon request. The city may charge a fee to copy a record or records that is no greater than the charge a fee to copy a record or records that is no greater than the cost of the medium on which the record or records are duplicated.
I think that's fine, but I would put a notation to wordsmith.
Yeah, that's what I will do. Okay, simplify this. Okay.
Okay, so then continuing, same section, paragraph B, last sentence, at insert, requests shall be made through the department, board, commission, task force, or committee whose meeting is recorded, period. And then, I'm sorry, an additional sentence, requests shall be completed in the order of receipt, comma, and no additional charges shall be assessed for expedited service, as Member Anderson had suggested.
Okay.
Now, new section C.
When you say new section C, meaning add a new section or jump to section C?
I'm sorry, at new paragraph C. And then
okay. Is the current C turning to D?
To D.
Okay.
And at sequitur.
Okay.
Oh, that's the end of the section. Okay, yeah. So C becomes D, inserting new paragraph C, closed session recordings, comma, made pursuant to section 6714B, comma, shall be made available whenever all rationales for closing the session are no longer applicable, period.
Okay.
Audio recordings of closed sessions of bodies, or can say meeting bodies, covered by this ordinance capital O, ordinance. Wherein the justification for the closed session is, open quote, anticipated litigation, closed quote, shall be released to the public in accordance with any of the following provisions, colon.
Okay.
2 years after the meeting, if no litigation is filed, semicolon.
Mm-hmm.
Upon expiration of the statute of limitations for the anticipated litigation, if no litigation is filed, semicolon. Ready?
Yep.
As soon as the controversy leading to anticipated litigation is settled or concluded, period.
Okay.
And then in what would now become new letter D, just some simple strike throughs and one sentence insertion, quick
Okay.
insertion. In the middle, where you see California Public Records Act,
Mm-hmm.
and then it says, and shall not be erased or destroyed, period.
Uh-huh.
Okay. Add a comma, remove the period, put a comma, and then insert, unless the recordings are being transferred into a different format for public access retrieval or archival requirements, period.
Okay.
2 sentences down, you'll see the words written out 72.
Yeah, I changed it to 72 numerals.
So, yeah, you can just add in parentheses the numerals. And then about 3 sentences down, sentence ends in thus by the city.
Mm-hmm.
This subsection, and now change C to D.
Mm-hmm.
And then scrolling down to where it says requirements for recording closed sessions as stated in strike section 67.8-1
Mm-hmm.
and insert subsection C.
Okay.
And then after continuing, and for recorded meetings of strike boards and commissions enumerated in the charter, insert policy bodies.
And leave as stated in subsection B above.
Correct.
Okay.
And that's the end of that section.
Okay, hang on one second. Okay. Member Anderson.
Yeah, I just wanted to remark, for Government Code Section 6250, that
Mhm.
now has a new number.
Ah,
That-
right. Yes.
So-
Yeah, 7920.
7920, and that should be
Software.
corrected in B above and also in this.
Thank you. Yeah.
You're welcome.
And also where it says city's website, that actually is now not sfgov.org. It's going to be
Oh, wait,
changed to
what
SF.
section is that?
That's in with the new D in the
Yeah.
middle.
Oh, right. Just take out sfgov.org.
Yeah, I would just take it out. Just say the city's current website, because the domain name has changed.
Yeah. And I think website has been one word for a long time.
Yes, that's true. I think it's in the dictionary now.
Okay, these are some good changes.
And the next section is substantive for me.
Public testimony.
Okay, can we have a few minutes to read this one?
Yeah.
Okay. We are so close to the end. This is great. Okay. Or how about this? Do you want a few minutes to read 15, 16, and 17, and then we'll just power through?
I'm good with that.
Okay.
Okay. And may I request that we have a 5-minute break for bio?
How about this? We're going to give 15 minutes, and you can use whatever subset of that, or do you want 20 minutes to read
15.
and? Okay.
Yeah.
Okay, we're going to reconvene in 15 minutes. Use the time to read, to take a bio break, to stretch.
Okay.
Okay. Actually, I'm going to stand up too. Oh my goodness.
So we're in recess.
We're in Yeah, you know what? Let's say that. We are in recess for 15 minutes and come back prepared to discuss section 6715
16 and 17.
and 16 and 17.
15 minutes, so that's 40 to 8.
Yep.
Is it just me or is it cold in here?
It's cool.
Yeah. Oh, it's not hot.
But it helps. If
Huh?
it were warm in here, that would not be good.
It's not good. We've had it like that. It's been bad when that happens. Hey, Lila,
Yes.
just wanted to remind you.
Okay, we are returning from recess. Ms. Lachey, if you could call for attendance again, make sure everyone's here.
Member Pilpel, absent. Member Anderson.
Present.
Member Anderson present. Member Wolf.
Present.
Member Wolf present. Sheila Hood.
Present.
Sheila Hood present. We have a quorum.
Okay, so we're picking up again with section 6715 and public testimony. Then we'll go on to 6716, which is minutes, and 6717, which is public comment by members of policy bodies. So starting with the public testimony section, who would like to go first?
I'll go again.
Okay.
But I think after you might want to rethink if we want to still go to 17.
Okay.
This is some of this is substantive. There's a number of additions in this one.
Okay, I'm ready.
Okay. 6715, public testimony. In the first sentence, after, let's see, every agenda, blah, 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 opportunity members of the public to directly address a policy body on and insert any item, singular, of interest to the public, that, and strike R, and then insert is within, insert the policy body's subject matter to the end of the sentence.
Okay.
Then strike however all the way to the end of A.
Of A. Okay. Can I ask why?
Then insert this provision shall also apply to all meetings of the Board of Supervisors and its committees. Now, that may be controversial because it depends upon the provisions of the Brown Act.
Wait, but isn't it already covered? Because every agenda for regular meetings shall provide an opportunity for members of the public to directly address a policy body. So you think we also, the Board of Supervisors is a policy body. Yes?
I understand that, but if you read that next sentence starting with however, that means it's a caveat.
Right, but if we delete it, I don't think you need the section that says this provision shall also apply to all meetings of the Board of Supervisors.
I understand that, but I agree with some other folks that it's still worth mentioning because that we're removing a section that directly addresses the Board of Supervisors. But if you think not, I'm okay.
I would say if that's, I think we can go without it because if it's already covered by the fact that it's a policy body.
Okay.
Unless you think.
Well, the thing is that the first part is just for regular and special meetings. A lot of commissions.
Actually, it just says regular meetings.
Oh, are you sure?
It says every agenda for regular meetings. And the funny thing is it doesn't even start with regular meetings of what? Like policy body. I would argue.
Wait a minute.
Every agenda for regular meetings. Regular meetings of who doing what.
Okay, so then there would be an insertion of and special meetings.
Right, but regular and special meetings. But we don't even say who is meeting yet. So
yeah, it does to address a policy body.
Right, but it's so far into the sentence. In any case.
Okay. So every agenda for regular and special meetings of a policy body.
Yeah.
Okay. The difference is that many policy bodies don't have committees. And the provision for the however part is a specific provision within the Brown Act. And the reason why I said it's controversial to strike it and then just add what I said is because we talk about these laws being enhancements, the Sunshine Ordinance being an enhancement. I'm not sure whether this would be an enhancement that would conflict or be allowed.
Well, does this apply to committees of other policy bodies?
Yes, that already is covered, but
no, it's not. It's been because right now this section says every agenda for regular and special meetings of a policy body shall provide an opportunity for members of the public to directly address. It's a little redundant now. Okay. The policy body on any items of interest to the public any item of interest to the public that is within the policy. The changing of why did you want to change it to singular?
Change what to singular?
You changed the policy body on any item of interest to the public that is within the policy body's subject matter. Are you trying to say that people can only talk about one thing at a time?
Well, there's only one item on an agenda at a time.
No. When we have public comment, they can talk about, when we have general public comment, they can talk about several things.
It says here.
And when you say items of interest.
On any item of interest to the public. I think it's just, I don't know, maybe it's just a word of art, but it could be any items. It's fine. Any items of interest to the public.
Okay. Regardless, does this apply to committees?
It does apply to committees because if you go back to the definitions of a policy body in 67 3D, it talks about any board, commission, committee, or other body created by the mayor or a policy body.
Okay, in that case, I would not specifically call out all meetings of the Board of Supervisors and its committees because it's redundant, because it already applies to all of those.
Yeah, my only concern is that the legislative body of a local agency is called out independently in the Brown Act versus policy bodies that might be created under the mayor in the executive branch. Because the mayor is a singular seat, a singular office, while the city council or a board of supervisors is a legislative meeting body. The mayor acts solely, autocratically, or independently.
But that doesn't affect whether the Board of Supervisors and its committees qualify as policy bodies.
It's true, except that the Brown Act makes a distinction. And that's why. And if the Brown Act, if state law is going to make a distinction, then, it would have, we do say in 67 3D, a policy body shall mean one, the Board of Supervisors. So, it's already defined.
Yeah.
So, you're right. You're right. I think that my idea was not to lose the flow of maybe the redundancy there.
Here's what I would say. I think we're looking at this as responding to the material that we're taking out. But once it's gone, and we're just asking people to look at what we're leaving behind. So, they're not going to see the traces of what was there before. Okay,
that's fine. Again, we've defined the Board of Supervisors being a policy body anyway.
Yeah.
But then, if that's the case, then we might want to then address a policy body, and or its committees.
Okay. Yes. Okay. I think that is a good idea. Okay. Hang on. Let me do this.
Yeah, because this. No, Member Anderson, I was just in reading this again on the however. This specifically addresses the fact that public comment need not be noticed if it's a item that the committee is reviewing was done by board members themselves. So basically this carves out an exception for when you have to do the public comment
Well,
that the agenda doesn't. You see what I'm
mm,
saying?
no, that however part means that if public comment were to be provided in the committee, that there's no requirement to provide additional public comment for the same item at the Board of Supervisors.
And you're
It's-
saying that they do have to let them comment at the Board of Supervisors, even if it's been discussed in committee?
Yeah.
Yeah,
Okay. That's why it's controversial. You're going to eat up more time.
well, it's the question. Well, wait a second. Are you prioritizing time over public interest?
No, I'm just saying that's why it's controversial. I'm not prioritizing, but I can
Yeah.
see why there's going to be pushback.
Right.
Yeah.
So, but, like I said, I mean, I'm throwing spaghetti at the wall,
Yeah.
right? Okay, so now B, remove strike special. And then at the end of the sentence ending in thereupon, insert new sentence. And this is actually more or less the same language as what we struck out from above.
Which is, you said, okay, after thereupon period, you want me to add something. I'm not sure what you want me to add.
So we're going to add, and let me just make sure I copied and pasted exactly what it is. Okay, it's not fully the same. It's the same sentiment as the however from the above paragraph.
Okay.
But it's a little more, there's some additional items. So I'll just read it.
Okay.
However, comma, in the case of a meeting of the Board of Supervisors,
Oh, slow. Uh-huh.
the agenda need not provide an opportunity for members of the public to address the Board of Supervisors on any item that has already been considered by a committee, comma, composed exclusively of members of the board, comma. Give me a cue.
I'm ready, but I don't think you need commas around that clause. But
okay, well, I'm continuing.
Okay.
At a public meeting wherein all interested members of the public were afforded the opportunity to address the committee on the item, comma, before or during the committee's consideration of the item, comma, unless the item has been substantially changed since the committee heard the item, comma, as determined by the board, period.
Okay, let me look at this.
It's similar to what was struck out above, but
Okay.
it's a little more nuanced.
Okay, I'm going to read this. I'm going to read back what I have. It is a little wordy, but I understand why all these words are here. However, in the case of a meeting of the Board of Supervisors, the agenda need not provide an opportunity for members of the public to address the supervisors on any item that has already been considered by a committee composed exclusively of members of the board at a public meeting wherein all interested members of the public were afforded an opportunity to address the committee on the item before or during the committee's consideration of the item, unless the item has been substantially changed since the committee heard the item as determined by the board.
Correct. Now, if you read what was crossed out in the previous, you'll see that it means the same. It just is pertaining specifically to the Board of Supervisors. It's actually just to create some clarity, because having it in the above paragraph was it seemed a little mishmashed, and we wanted to make it so that it didn't matter whether it was a regular or special meeting. It's all meetings.
Right.
I mean, that's what I was doing. There's one additional sentence.
Okay. After this one in section B?
Yep.
Okay.
One additional sentence. However, comma.
You want two however sentences?
Yep.
Let's think about this, but go ahead.
All right. Well, you can wordsmith it. I'm not, my skills sometimes are not that good. However, comma, nothing in this subsection is intended to exempt the Board of Supervisors plural possessive committees from the general public comment requirements under subsection A. So that's why I put in that sentence. This provision shall apply to all meetings of the Board of Supervisors and its committee in A, because that is specific for general public comment.
So here's the good news. That sentence works without the however. So I'm just going to cut that however.
Okay.
There we go. Okay. Okay.
So
Member
A
Anderson,
is,
what do you think?
let me just explain. A is for general public comment, and B is that special Brown Act carve out for the Board of Supervisors.
Okay. Okay. Are we ready for C?
Yeah. So C gets its own title. And so you'll insert time and order of public speakers. And the preamble sentence will remain the same, except at the end, after but not limited to, insert the following.
Hold on. I don't see after, but not, I see including but not limited to.
Right. And then insert the following.
Okay.
Colon.
Okay.
And then insert a sub paragraph number 1.
Okay.
And strike regulations limiting the total amount of time allotted for public testimony on particular issues for each individual speaker.
You said strike that.
Strike it.
Okay.
Okay. And then leave, each policy body shall adopt a rule providing that each person wishing to speak on an item before the body at a regular or special meeting shall be permitted to be heard, insert at least once for up to insert a minimum of 3, and then add the numeral 3 in parentheses, minute.
Actually, that we might debate that later. Numbers under 10, I think just spell out. Numbers over 10, we use numerals.
Okay, that's
Yeah.
fine. Again, it's a wordsmithing thing. I'm just trying to be consistent. Okay, so 3 minutes and then insert per agenda item, period.
Okay, here's the thing. Permitted to be heard at least once. I get that. For up to a minimum of 3 minutes. Why don't we say for at least 3 minutes per agenda item?
Okay.
Yeah. So we're essentially saying you can't give people less than 3 minutes for any agenda item, but you may give them more.
Correct.
Okay.
Okay, and then a new subparagraph 2.
Uh-huh.
Oh, my cursor's stuck. Come back. There we go. If the chair of a meeting finds that a large number of speakers wish to speak on a particular item, comma, the chair may reduce each speaker's time, comma, but not to less than 2 minutes per speaker, period.
Okay.
Now, I don't know what defines large. Like in our meetings, 5 would be large.
Mm-hmm.
Right? So I don't know if that's, it's very subjective. So I'm just leaving it in there and open for discussion. Okay. All right.
Should we limit the total number of minutes that a speaker may speak at any one meeting?
No.
Okay.
No, you those kinds of things I think should be left open-ended. It's really
so if there
up
are
to
10 agenda items, a member of the public may speak for 30 minutes.
well, there'll be public comment for 30 minutes.
Right. Okay.
All right. Continuing, next, a new sentence. The chair shall announce any modification of the 3-minute minimum before public testimony on that item commences, period.
Okay.
A new sentence. The chair has discretion to provide extra time for those who need accommodation, for an interpreter, or a disability, period. And then the last sentence remains the same, except strike uniformly.
Hold on. Last sentence. I don't see.
Time limits shall be applied.
Hold on. No.
Is that in there?
Oh, but that was in section 1.
Oh, yeah. But now that everything has been moved down.
You want me to move that to make it a 0.3 or move it down to section 2?
No, it should be at the last sentence of 2. Maybe
Okay.
I didn't notate that correctly myself.
Okay.
So I guess it would be a new sentence there. Time limits shall be applied consistently to members of the public wishing to testify, period. And that's the end of 2. Now, the only issue here is, for me, when I kind of rereading this, is the chair shall announce any modification of the 3-minute minimum before public testimony on that item commences. It's not an item per item modification. I think I overlooked that.
Let's say before public testimony begins on that item.
Well, the problem is it should be consistent for all items on.
Why? But you might not know at the beginning of a meeting that 100 people show up later in the meeting.
Yeah, true. But okay. Well, yeah, this is for a particular item. So yeah. Okay. All right. Yeah. I guess I did think of that. Okay, good. Okay. That's fine. Leave it. All right.
One quick thing. I just want to, so you wanted to say time and order of public speakers, but we don't actually say anything about order. So should we just say time allotted for public speakers?
It's coming.
Oh, there's more. Okay.
Oh, there's a lot more.
Okay. So this is subsection 3?
This now subsection 3
Okay.
has its own title. The chair may allow a designated.
No, that's not a title.
What do you mean? It's not.
You said it's the chair may allow. That's not a title. You said it's got its own title, or
well, it's got its own kind of. It's got its own kind of heading.
Why don't you just read it to me? I'll type it in and we'll figure out if it's a heading or if it's just what the subsection is. Okay.
3, the chair may allow a designated speaker, and in parentheses, S for plural. So it's speaker or speakers.
Mm-hmm.
And then a new subsection A, capital A.
Okay.
If allowed by the chair, comma.
No, you've already said allowed. What may the chair allow them to do?
If you let me finish the sentence, you'll hear it. That's why I said it's a title. Okay, and then A, if allowed by the chair, members of the public may, comma, for any item agendized for adoption or discussion by any policy body, comma, authorize a designated speaker or speakers, comma, who will present the arguments regarding an issue for adoption for up to 15 minutes, comma, give me an
Yeah, go ahead.
or for a time equal to that allowed to the department or presenting party, comma, excluding the time required to answer questions posed by the body, period. New sentence. The designated speaker or speakers and the department or other presenting party for an item to be adopted shall be allowed to speak in summary for 5 minutes directly prior to the vote by a policy body.
Okay, what's B?
B shall be is, it shall be the responsibility of the designated speaker to file, comma. And then there's this with the clerk or secretary, and then whatever nomenclature we're using for that, comma, a capital request to capital authorize a capital designated capital speaker prior to the commencement of an item and to guarantee that at least 6 members of the public, comma, present and prepared to speak, comma, have designated their allotted speaking time to the requester, period. Again, have designated their allotted speaking time to the requester, period.
Okay, let's keep going. I might make some suggestions later on tightening this up, but I'm getting the gist of what you're trying to do here.
Okay. C, this is one sentence. The chair shall, comma, by a show of hands, comma, determine that a designated speaker has the consent of 6 members of the public who are present and prepared, comma, to speak on an issue, comma, and shall announce the designated speaker or speakers. And that's the end of 3.
Okay.
Now 4. And again, I put a title there, and it's called Rules for the Order of Speakers.
Hang on one second. Okay.
And the preamble under it is, a chair shall accept public testimony in a fair and even-handed way, comma, without manipulation in the order of speakers, comma, absent, I guess, of good cause. Period. Each policy body shall adopt regulations for the order of speaking, comma, which shall include, but not be limited to, the following, colon.
Okay.
Give me enough. Ready?
Yep.
Okay. To the following. A, capital A.
No, it's numeral 1.
No, it would be 4. We're
No,
on
you've got
4.
4. You've already got A. Now this is numeral 1.
No. It's 4 where it says a chair.
Yeah,
That's
A.
not A. That's just a designating a singular chair.
So
Like
let
chair
me
or
just tell
the
you what
chair.
I did. I gave you the title, Rules for the Order of Speakers. And then the text about that is A.
No, it's just a preamble.
It's just a chair.
So you can exchange the word a for the. You could put the chair.
Hang on one second.
If you want to do it A, there's just no B. So it's just a preamble, and then there are three points below it.
Okay, I think there's so much going on here, we've lost parallel structure.
Well, I don't see it that way, at least on my page.
Go ahead.
All right, so after, but not limiting to the following colon would be subparagraph A, speaker cards, comma, when available and submitted, comma, shall be used in the order of submission to designate the order of speakers, comma, except that the chair may alternate, quote, pro, unquote, and, quote, con, unquote, speakers if they are designated on the forms, period. New section, capital B.
Mm-hmm.
Members of the public who have not submitted speaker cards may form a line to speak and shall be called upon in the order of appearance at the front of the line, comma, except that the chair may allow disabled or elderly and frail members of the public to speak out of turn. Period. New section, subsection capital C.
Okay.
If a meeting is recessed, comma, adjourned, or the chair has ordered a break, comma, the order of speakers from the previous session shall be maintained, period.
Okay.
No changes to D, no changes to E, adding a new F, and this would be the end of this section, but F is fairly long.
Okay.
So new F, Members of the public shall have access to all audio-visual equipment used by a department or policy body for presentations made to that policy body consistent with time limits provided in subsection C, period.
Okay.
To the extent feasible, comma, prior notification in the agenda or public notice that a presentation will be made using audio / visual equipment or technology shall be provided, comma, listing the specific equipment. Now I know the dash at the beginning and the slash at the end, you know, it's 6 of one, half dozen of the other. I mean,
I will look at this later and make things consistent, because it's actually it's distracting to have different usage. So
yeah,
we might just change the wording.
Yeah, I get it. Okay, now, okay, oh, I'm sorry, that's the end. That's the end for me.
Okay. This is a lot, and I will have comments, but I don't want to slow us down right now because I actually need to absorb this.
Okay. There's a lot of, it's, you know, kind of accessibility kind of stuff in there too, so.
Member Anderson, do you have anything that you would like to add to 6715?
What I would like to add is that I need also the time to read it all the way through with the changes and kind of digest what it is we're trying to do here because of the specificity of it.
Here's a question about that. If actually that gives a reason maybe to, well, yeah. We'll just have as many meetings as we can. Okay.
I mean, some of this is kind of common sense stuff that doesn't happen but should be written. I think once you read it through, you'll.
Yeah, I think some of it can be tightened up because there's and that's I think it's important that you've given all of these details so that we understand what you're going for, but then within each section, I think maybe we can reduce some of the repetition without losing your meaning.
Right.
Yeah.
Thank you. Thank you.
Okay. Shall we go on to 6716, which is minutes?
Yeah. And I have minimal edits to that.
I bet the first one is the clerk, secretary, or administrator of each policy body, strike,
correct,
board and commissioner shall record the minutes. Okay.
Yeah, it should be all policy bodies.
Yeah.
And then at the end where it says each regular and special meeting of, and then strike the board or commission.
Hold on.
Sorry.
No, and actually, I'm going to say of each policy body only because we're saying the clerk, secretary, or administrator, and it's not of all policy bodies, it's of each policy body.
Yeah.
Okay.
Okay,
Sure.
and now what do you want to change?
And then at the end, strike the board or commission. And insert those bodies or that body.
Okay. Yep.
Okay, and that first sentence will be a new subparagraph A.
The minutes will be subparagraph?
Yes,
Okay.
yeah, the clerk or secretary, that will be a subparagraph A.
Wait. Oh, you want this to have sections. Okay.
Yes, yeah.
Okay.
And then the sentence that begins, the minutes shall state the time, that is a new subparagraph B.
Okay.
And after the names of the members attending the meeting, comma, insert time of each members, that's singular possessive, arrival, if after commencement of the meeting and the time of each member's singular possessive departure, if prior to the adjournment of the meeting, comma, the roll call of each matter considered at the meeting, comma, and now insert the time, comma.
Oh, wait, where do you want the time?
At where the next sentence where it says the roll call vote on each matter considered at the meeting.
It says, right, we already have the time the Board or Commission began and ended any closed session. So you want the time?
Yes.
Okay,
And then, but then it says the roll call vote on each matter considered at the meeting. Does it say that there? Hold on. The roll call vote. Right. So the current language says the minutes shall state the time, the meeting, so on and so on. Okay. And then I gave you the insertion, and then there's a comma, and then it says the roll call vote on each matter considered at the meeting, and then that comma, and then insert the time, comma.
The what time?
It just if you can just type it in and let me finish, and then we can read it back, if you don't mind. The time, comma, based on the meeting dash start time of 00:00, comma, that the policy body began and ended discussion and action on each item of the agenda, comma. This is already a very long sentence in the ordinance anyway.
Yeah, this is not exactly working.
I get that, but it was hard to break it down because it's actually part of a flow of how the minutes are to be notated.
I have a question though. I have a question before we go any further on this. Are you introducing a practice that nobody uses and which there will be great opposition to throughout City Hall, in which case I don't think we should put it in the ordinance? If you're telling people that they need to do timekeeping in a way that they are not already doing, there is going to be mutiny.
Yeah.
Ms. Leger is nodding.
Yeah.
Someone's going to say something.
Well, one point is that is notating a member's arrival.
Right, that's different than saying that you need to use a certain, 00:00 timekeeping practice. That's like, let's think about this. Like, let's think about what are you trying to accomplish and what's the simplest way we can ask for that instead of making a really complicated set of instructions that are going to be difficult for people to comply with. That's why I'm a little bit concerned, even though like I think being specific and detailed is helpful. I think there gets to be a point where too much is too much.
I would concur with that.
And the only reason I'm starting to push back on this is because in terms of minutes, I think it's really important to document what is actually happening.
So let me reorganize this, because actually what should be done in this, for this paragraph, is this is a list of things already, with or without even without my 2 additions. It's a list broken up by commas, and it actually should be bullet points to make it clearer to understand, just of the original language.
Yeah, we can do that. Give me 1 second and I'm going to do this, and I'm going to tell you what the bullet points I have are. And then we're going to figure out whether we need to, and I have the ones you already have. And then we're going to think about which ones we need and which ones might be extraneous. Give me 1 second.
Okay.
Okay. So right now I've got A, the clerk, secretary, or administrator of each policy body shall record the minutes for each regular and special meeting of that body. B, the minutes shall state, and then these are bullet points, the time the meeting was called to order. Next one, the names of the members attending the meeting. Next one, the time of each member's arrival if after commencement of the meeting. The time of each, next bullet point, the time of each member's departure if prior to adjournment of the meeting. Next one, the roll call vote on each matter considered at the meeting. Next one, the time based on the meeting start time of 00.00 that the policy began and ended discussion and action on each item of the agenda. I don't like that one. Next one, the time the board or commission began and ended any closed session. Next one, the names of the members and the names and titles were applicable of any other persons attending any closed session. Next one, a list of those members of the public who spoke on each matter if the speakers identified themselves, whether such speakers supported or opposed the matter, and a brief summary of each person's statement during the public comment period of each agenda item. And then I'm tacking on to that bullet point, any person speaking during a public comment period may supply a brief written summary of their comments, which shall, if no more than 150 words, be included in the minutes. And then,
Okay.
And the time the meeting was adjourned, and that would be the last bullet point.
Okay. So, there was, you missed the time the meeting was adjourned.
No, I just said that.
Yeah.
Oh, okay. So then the following sentence, any person.
So I moved that up to the where we say a list of those. So this is one bullet point, a list of those members of the public who spoke on each matter if the speakers identified themselves, whether such speakers supported or opposed the matter, and a brief summary of each person's statement during the public comment period for each agenda item. Any person speaking during a public comment period may supply a brief written summary of their comments, which shall, if no more than 150 words, be included in the minutes. I think it's important to put that next to the place where we say, talk about members of the public giving public comment.
Okay, so I've got some edits in that sentence.
Okay.
So it is any person, and then strike speaking during public comment period.
Okay.
May, and then strike supply a brief.
Mm-hmm.
And then insert submit written, and then strike summary of their comments, which, and insert.
So do you want to say submit written comments?
Submit written comments to be, and then again, continuing with insertion, to be attached to the minutes.
Hold on. How about written comments of no more than 150 words?
Actually, I have that as a new sentence.
I think if you say submit written comments of no more than 150 words to be included in the minutes.
So what I was going to say is if no more than 150 words, the comments shall be included in the body of the minutes in the section dealing with that item or matter. It's a different thing.
So you're saying that people could submit 20 pages of written comment that would have to be attached to the minutes? I'm just thinking about being practical, because you know it's imbalanced, because people who show up in person and could only speak for 3 minutes, and then you're saying if you don't show up in person, or if you just submit written text, you can submit whatever you want and flood the field so that nobody else's material will ever be seen.
That's true. Well, the idea is if it's 150, if it's no more than 150 words, that it should be included in the minutes. As far as what a maximum would be beyond that for it being attached, you know, that I'm open.
I mean,
you know, give it a limit.
because this is for public comment, right?
If somebody wanted to submit a report,
Uh-huh.
a public report, as part of their public comment,
Mm-hmm.
so they say, I'm blah, 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 I'm talking about this report, 2 minutes goes by, and I'm submitting this report for the record, you'd want it attached to the minutes for that record, for that meeting. And that does already happen from time to time. People will, give handouts and whatnot that should be reflected in the minutes because it's part of the meeting.
Okay, so what are your 2 sentences?
So the first one is any person may submit written comments to be attached to the minutes and noted in the item, period. If no more than 150 words, the comments shall be included in the body of the minutes in the section dealing with that item or matter, period. The minutes shall also include the text.
Okay,
of
I'm going to have
any
to start over again with if no more than 150 words. And I am going to edit this down because this is becoming, even just take, like, this is becoming so, this is so wordy that I think we're making, yeah, okay, I'm going to take dictation, but then we're going to have to boil this down. Like, this is,
Okay, that's
it's
fine.
getting so cumbersome. I feel like it's getting less,
But
the
it's all
utility is being lost.
It's part of an existing sentence.
No, but we're like, it's things just keep, okay. If no more than 150 words.
If no more than 150 words, the comments shall be included in the, and then insert body of the minutes, and then insert in the section dealing with that item or matter, period.
Okay.
Last sentence, a new sentence. The minutes shall also include the text
Hold
of
on,
any.
hold on. Is this still part of the same bullet point? Or is this? Okay.
Yes. The minutes shall also include the text of any resolution adopted by or modified by a policy body within the body of the minutes or as an attachment, period. That's the end of B.
So that's a different bullet point.
Okay.
And I guess we'll end with the time the meeting was adjourned.
Okay.
Within the body of the minutes or as an attachment. Why as an attachment? The minutes shall also include the text of any resolution adopted by or modified by a policy body within the body of the minutes or as an attachment. Why would it be as an attachment?
Because some resolutions are huge. Some are one-pagers that are simple, and others can be huge. And actually, maybe the word resolution isn't the right one because the Board of Supervisors, there's a difference between resolution and ordinance.
Yeah. Yeah.
maybe it's just be action.
Yeah, I think action. Or action taken. Or I don't know.
Action for now.
Yeah. I'm sorry. I'm actually a little stuck on this one because I feel like it's
Are you stuck on there not being a limit?
no. If we're already talking about so I think we should just leave it as okay. We already say the roll call vote on each matter considered at the meeting. Wouldn't that imply that they're like, wouldn't minutes describe what each matter is? So you want the text of any action taken. I guess if we're talking about action versus resolutions versus
Which, are you talking about the last sentence?
Yeah, which I've already
also?
changed. The minutes shall also include the text of any action taken. I mean, it's actually, the minutes shall, how about let's take out text. The minutes shall also include any action taken by a policy body.
Okay. The reason why that's in there is because I've read some minutes where they just state an item and an action with no information. And then it's impossible to get them to reveal what it is that they took action on. You'd have to go back and listen or watch the recording so that the minutes don't reflect enough information. Or you have some bodies where they hand out stuff to the decision makers and there's not enough for the public. And so by including it in the minutes, then when the minutes come out, the public has it.
Okay, how about this? Because it's bullet points, why don't we say any action taken by a policy body, comma, with the text of any resolutions, or what was the other thing you said? Resolutions or
adopted by or modified by a policy body.
But it wasn't just resolutions. You said
Action.
No, not actions. What was the third word?
Resolution.
Actions.
No, it was that we were talking about resolutions and you were saying, oh, but that doesn't include.
Oh, ordinances.
Okay.
But then if you just say actions, that includes whether it's a resolution, it's any action the Board of Supervisors would take. If we're talking about the Board of, let's say the Board of Supervisors. So the Board of Supervisors, they have two different types of actions. They have one for resolution, which the mayor has no involvement in. And then you have ordinances, which the mayor does have involvement in.
Okay. How about this? And I'm just trying to, Okay, any action taken by a policy body, comma, with the text of resolutions or ordinances adopted or modified in the body of the minutes or as an attachment.
Okay.
Modified, included in the body of the minutes or as an attachment.
Mm-hmm.
Okay.
That's fine.
This is Member Anderson. Do you think there's a way that we could encourage within these minutes to have a tie back to an agenda item so that way we can say this action refers to agenda item, whatever it is. And then that way the public would have greater access to finding out exactly what it is, because on the agenda, they're going to have to put more, well, theoretically, more information on what it is they're going to be discussing.
So we could add a sentence, all actions should refer back to a specific agenda item.
Yeah. And then you can just go back and look at the agenda item and go, okay, this is, or if you wanted to hear what the discussion was around it and what was presented about it, those should be in the agenda too, if they're going to be talking about it.
I think that makes sense, because then people, yeah, because the whatever material was in the agenda, they'd probably be interested in.
Exactly.
That kind of is already happening with SFGov TV, where they're beginning to put time codes at each agenda item, but it doesn't necessarily reflect it in the written minutes, I don't think. I'm not sure how it works with that. It's across the board in every commission or every meeting. It may be in some and not others.
But this is Member Anderson, but it would still give the public an opportunity to tie what's in the minutes back to what was in the agenda.
Exactly.
So it gives them a bigger head start. If that's what they choose to do, is to go back and see exactly what that agenda item covered and what kind of documents were presented along with it.
I agree. Okay, you ready for C?
Yes.
Okay. C is just a couple of insertions. The draft minutes and insert and any attachments thereto from, I'm sorry, and strike the word of. And then it goes on, each meeting shall be posted on the policy body's website.
And made available. I had the exact same edit.
And be available for inspection, copying, blah, 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 no later than 5, and strike 10 working days and reduce it to 5 business days, which is more or less the same. After the meeting period. And then the same below where it says 10 working days, 5 business days. And then in the last sentence, strike Braille or increase type size and insert alternative formats for persons with disabilities.
Okay, I have one more addition. Well, I want to discuss, when you say the draft minutes, what do you mean by attachments?
And any attachments thereto.
Right. What do you mean by attachments? What attachments are you picturing with the minutes?
From what is in the above.
Okay. Here's what I would like to say. Instead of any attachments thereto, why don't we say any associated attachments from each meeting?
Okay.
And then in the second sentence, the officially adopted minutes, I want to say, shall be posted on the policy body's website and made available for inspection, blah, blah, blah. Same, just parallel to the one above.
Right.
Okay. Anything else?
No.
And then the last sentence, and then change all the 10 working days
To 5. Correct.
business
Yes,
days.
yes, yes.
And then the last sentence, strike Braille or increase type size.
Right. And you said, do you change it to alternative formats for persons with disabilities?
Correct.
Okay.
And that's it. That's it.
Okay. We're almost done. 6717.
Okay. Here I have just one sentence to add.
Okay.
In the middle, sentence ending with state or federal law or of this ordinance period.
Mhm.
Add new sentence. Every member of a policy body shall be allowed to speak freely on any issue before the body, subject only to time limits, comma, which shall be imposed on all members equally, period.
So we're basically saying every member of a policy body shall be allowed equal time to speak freely on any issue before the body, subject only to time limits.
Yeah.
I have a question regarding this one, and it's funny because I thought I didn't have any comments on it. What about conflict of interest? And like if you recuse yourself, then because sometimes we have recusals and then people leave. Can you recuse yourself and say, I'm just going to be a member of the public for this and I'm going to speak on this matter?
That's the purpose of this whole section. And it's allowing them to be able to speak, even if they are a member of a policy body. People will know that if they want to speak during public comment at another commission, some other commission.
I guess my question is, you can't do both in the same meeting. You can't.
Well, in the same meeting, because you're already there, you already have the opportunity to speak kind of as long as you want.
Right. It's unlimited. Yes. Yeah.
Right. And a lot of people will say, look, speaking for myself, people will preamble a comment by saying that. They'll say, personally, I think this, but in my position here on this body, I would say that. And, so they have the ability to kind of go back and forth in that way. This particular section is to remove any kind of restriction by any superior that would disallow a person from a member of a policy body to speak on to some other policy body. So if I'm in my community and I have an issue with the planning commission, I'm on this policy body. I can't, just because I'm a public official doesn't mean that I should be restricted from speaking publicly on some other issue in some other policy body. It sounds kind of like anathema in a way, but that happens elsewhere in the country.
So here's the thing. Let's read this sentence by sentence. So public comment by members of policy bodies. So right now it says every member of a policy body retains the full constitutional rights of a citizen to comment publicly on the wisdom or propriety of government actions, including those of the policy body of which he or she is a member. So we're looking at that. Is that it's not limited in the task force. Is that limited in other places, or have there been attempts to limit people speaking in other places?
Yes.
Like as members of bodies?
Yes.
Okay. Okay. So policy bodies shall not sanction, reprove, or deprive members of their rights as elected or appointed officials for expressing their judgments or opinions, including those which deal with the perceived inconsistency of non-public discussions, communications, or actions with the requirements of state or federal law or of this ordinance. Okay, I've got that. So the one you've added says every member of a policy body shall be allowed to speak freely on any issue before the body, subject only to time limits, which shall be imposed on all members equally. But we don't actually do that.
Yeah, we don't.
So is that inserting something that we actually want to insert, or is that going to cause problems?
Yeah, you know what? Let's leave that out. I need to rethink that one and discuss it with somebody who I was talking to about that.
Okay.
Yeah, let's leave that one out. We'll come back to that.
Yeah, because we also, as you pointed out, for those matters in which a member has recused themselves because there's conflict,
Right.
and then turn around and come back and speak, it's like, can you?
Well, generally, if they have a conflict of interest and they're recused, they have to leave the room.
Right. So they can't publicly comment.
Yeah.
So that isn't addressed here.
Right. And the way the law is written, the recusal is generally, it's always the way it's written, it's based upon like a financial conflict.
Right.
That's what it all comes down to. But
Right.
it always gets extended to, it doesn't look right,
Right.
and that kind of thing. Any kind of impropriety of any kind that person shouldn't decide on it. The question is should they then be disallowed from then speaking on it as a general member of the public? Or do they have to leave? And the reason why they leave is so that their presence in the room doesn't add any influence to
Right.
the rest of the decision makers.
And so if they become if they step around and become a member of the public, they still haven't given up their position on the commission. And I think we need some guidance on this, because I think this is, as it is currently written, is in conflict with, I think, ethics guidelines.
You mean the sentence I added?
No. This whole thing about
no.
you always
No.
get to, yeah, it is.
No.
How is it not?
It's not. It's not. This has already been adjudicated. This has been already adjudicated. I mean, this has already been added by the voters.
Right, but so you don't see the conflict?
No, I don't. This is not about them speaking at their own policy body. That's the sentence I inserted, was that they
it
get
says including those of the policy body of which he or she is a member. It's in the first sentence.
Yes. But all that's saying, it's giving them a scope of what they can or cannot say. It's not limiting their ability not to. It's not saying that they can't speak. It's just saying that they can speak out loud and be critical of government actions, including the ones of their own policy body. It's
Right.
like,
But
it's
there's
like
an
your
exception.
chair saying you can't say anything about what we're doing here out loud.
What if I have a conflict of interest?
The question is it the way the law is written on conflict of interest? It's based upon finance.
Right, but
So
But
then
here's
you'd
the thing.
be recused, and you wouldn't even be there to speak.
right, so that limits my ability to speak publicly on issues and government actions.
Yeah, but you'd be
In the
recused. You'd be recused first. So you couldn't even be there in person anyway.
Guess what I'm saying is I still, this implies that the way this is written, I understand what this is saying. It implies rights that are in conflict with what we're required to do in terms of recusing ourselves. So if you are recused, you lose these rights momentarily.
Let me give you an example. Maybe it'll help. There's a motion to either or a resolution to or an action to change the way an operation of the body works. Okay, and to one or more members of the body, they take they're indifferent to that. So now they're speaking out against it. That's exactly what this first sentence is more or less saying. Is that you're allowed your own thoughts and your own positions to speak critically, good or bad, of the government actions or the body that you're on.
Unless you've recused yourself.
Unless you've recused yourself. Well, even if you've recused yourself and then that action gets passed, if you come back, when you come back to the body and the, you know that the vote has already been taken, it doesn't prevent you then from speaking on it at maybe some other time. You had no part in that action. The action is over. But then they can speak about it later. They can have an opinion about it later.
In any case,
Yeah, because
I understand your thought about it. It's really a matter of what takes precedent. If you are recused, you lose your ability to speak on a matter because of that conflict. Because of the conflict, you can't speak on it.
as a member of the policy body.
As a member of the policy body, until that item has been, decided. After it's decided, you can speak about it all you want.
Exactly.
But not while it's happening, because you've been recused. So your kind of rights to speak on it, because of the conflict, take precedent.
Yeah, I think that's probably where there's, if we had gone forward with the recommendation for a change in the section of the Sunshine Act, we would run into problems because the change says that every member of a policy body shall be allowed to speak freely on any issue before the body, subject only to time limits. And so if you've recused yourself and you now say, I am no longer a part of the policy body as it pertains to this issue, now I'm Jane Q. Public out here making public comment. Not as a part, although perceptually, yeah, you're a member of the body, but you've taken off one hat and you put on another, and you've gone out to make your public comment on the issue that's before the body. So yeah, probably we need to think about it more.
Yeah, pull the item that I just added.
No, I did. You told me to take it out before.
Yeah.
I guess, not to. I think this is an interesting thing to consider. And actually, I just like it, as long as we're looking at this with a fine tooth comb, I think it's good to ask these questions and and interrogate it. Like, does this actually mean what it says, or is this in conflict with other policies we have? And if so, how do we resolve that? And
Yeah,
not tonight.
I think based upon your concern about conflict and being recused, I mean, if it were to say something about that here, to say like, except if, like, in the first sentence at the end where it says he or she is a member, or maybe he or she should be changed to they. They are a member.
Yep.
Maybe it should say except if they have been recused from that action and are restricted from all speech on the item, kind of thing. I mean, it could be like that. That would have to be, but we would have to find that.
We would need legal guidance on that.
Yeah, we need because there is state law around recusals, and there is city law around recusals. So that follows that, and it may even be more stringent. So.
Okay, I'm going to put a comment here saying we need more information on this. Yeah.
All right, I'm kind of at my limit. I'm sure you are. I'm sure your hands are.
Okay. Ms. Lachey, do we have, there's nobody in the room. Is there, is there anybody on the line?
It's not.
That's bad.
Hi, Ms. Peterson, no one else on the line?
There is not.
Okay, no need to vote. We would open it up for public comment, but there's no one to make public comment. Let's call the next item. And thank you all for your patience.
Hang on. Item number 8, announcements, comments, questions, and future agenda items by members of the Compliance and Amendments Committee.
I will bring up now, Ms. Leger had suggested that if we wanted to add another meeting, except Member Anderson, you said
I will not be available.
not available.
No.
I don't know about Pill.
Pardon?
I don't know about Pill.
Okay. What date had you suggested?
July 23.
July 23. Member Wolf, is if we were to have a short meeting on July 23rd, is that something you might be able to consider?
Hold on. 23rd.
Maybe just to go over the same things we just went over and get some consensus.
Yeah, that's fine.
Okay.
So Ms. Leger, if you could check in with Member Pilpel and see if he might be available, and maybe what we could do is go over the items that I wasn't here for and the items that he wasn't here for, so everybody will have gone over them with some subset.
And you're going to have it broken out between substantive to.
Yeah. Member Wolf, does that still make sense?
I didn't hear that.
To break out, well, and also realizing there's actually more for us to go over. I thought we were getting to the end. There's more after this. So, but perhaps it makes sense to, as suggested earlier, having two documents, one with just sort of there are several sections where we made such minor changes that they're not substantive, and then having the document with the substantive changes, which let me look at this. I really wish we could just have a Google Doc that everyone was working on and that was visible to the public, but I know we can't do that, and it makes things go really slow. So there you have it. Any other items for future discussion that either of you would like to bring up now for addition on a future agenda?
I have one. Go ahead.
Go ahead, Bruce.
I was just going to say, based upon your last point, Lila, I'm wondering if we could be extended an Office 365 Word doc that's collaborative, because that would be within the accepted software of the city.
I thought the concern, wasn't thinking it was so much that. I thought it was that we can't collaborate as members of a committee outside of the committee.
Yes.
And Ms. Peterson is saying that's why we can't do it.
Well,
Okay.
I'm not saying that definitively. That's my concern.
Yeah.
Oh, but I thought you meant like in a meeting, like we're doing here, where we could all collaborate on the same document together in a public meeting.
I think we still might have problems there unless we put it on an overhead and everybody else could see what we were doing.
Isn't there a flat screen to your right?
There is.
There is. I mean, is it? So that would mean like connecting my computer to the flat screen so everybody else.
Yeah, there's like 8 jacks over there that
Okay.
you can use to hook in.
Maybe we could try that next time. If that would be.
We've done it.
Yeah.
We've actually done it before, but years and years ago, like over a decade ago.
Okay, maybe we can think about doing that for next time. So at least everybody who is participating in the meeting could see it at least during the meeting.
Yeah. And one of the things we may want to think about in the future, not tonight so much, but as we were speaking of earlier with the AI, to run all our suggestions and edit through AI and see what it comes up with as far as setting up a.
Oh my goodness.
I know. Can you imagine? I wonder what it would.
What would it say?
I wonder what it would come up with. Yeah. Some of it good, probably some of it, garbage, but.
That could be an
General
interesting
Hood,
exercise.
That would be very
Yes.
interesting. I don't know what's the public records on rules on running your stuff through AI. I know there was something.
Are you
there's
thinking?
no law yet?
Yeah. Are
Says
you thinking
can't
for
do it.
suggestions on how to like clarify or simplify language?
Exactly.
That's interesting. Should we run the current version through and see what it says without all our edits?
Yeah, I'm sure someone's already done it. So
Well, I like using Claude.
Claude that's the software you use?
Yeah, Claude.ai.
I will check it out.
Much better engine than OpenAI, at least the current ChatGPT.
Question for Chair LaHood.
Yes.
As we look at options for using a shared document, this would be a document that would be shared in terms of viewing or shared among users?
I mean, in an ideal world, it would be shared among users, but I think that's not. I think that would run afoul of some other issues. But shared viewing, I think, would be shared viewing. It sounds like might be acceptable within the meeting, and it would be nice if we could have shared viewing beyond the meeting if the public was also able to view it. And I don't know, Ms. LaShaye is saying she doesn't think.
And the next question, you would want to be able to access it. You would want access to it.
Yes. Otherwise, what's the point? Yeah.
All right. Don't know the answer.
Okay.
Okay.
Yeah.
All right, so we can talk to our IT people about that, see what they would suggest for something that would work like Google Doc, and would allow everybody access to the same document and see the edits as they're being made and make other suggestions as you guys go along. Is that correct?
Yes.
Yes. Yeah.
Yeah, I can talk to IT tomorrow morning,
Yeah.
see what they say.
It'd be interesting. Yeah.
Yeah.
So, anybody have anything else?
Nope.
No.
Thank you all for having this discussion. And Member Wolf, I know I started pushing back on a lot of things, but there was a lot of changes.
I know.
So, should we call the next item?
Item number 9, adjournment.
So moved.
All in
Second.
favor?
Aye.
Aye.
Aye. Thank you, everyone.
Thank you.
Have a good summer. I know we don't have our full task force meeting in July, and we'll definitely see you in August.
Yeah. For
Okay.
Sure.
So you do want a July meeting? Get in touch with Pil and he agrees to it. You do.
If he's available and Bruce is available, I think it might be helpful even just to go over things we've already gone over to sort of get on the same page.
Okay, well,
Fabulous. Thanks, everybody.
Thank you.
Let's turn off the recording and the microphones.
Turning off the
Right.
recording.
Have a good one.